My lord, to mention, my lord, item number 130 of the monthly list, my lord, it's application for setting aside the award, my lord. I am the award holder. And my lord, I'm not opposing the prayer for setting aside the award. Not could it appear is to be mentioned tomorrow, my lord, so that lordship can pass the order.
I'm appearing for the other side.
My lord, friend appears not. It appears to be mentioned.
You're on the other side. I'm on the other side.
He is the
Unilateral appointment. Unilateral appointment.
Your lord.
The proceeding was there was a
My lord,
stay in the matter.
my lord, yes, my lord. More than that, there was a stay.
There was a stay.
So,
The award was passed.
The
34 or
34. So, my lord, we had jointly mentioned before the honorable judge, my lord, to set aside the award, even on oral mention, but the honorable court said, no, you file a formal application. That is the
That is the
application.
one.
Even before this, we had agreed.
Lordship's kind leave to mention a section 9 application. My letter of credit is going to be invoked. Lordship will consider keeping it any day on Thursday or on Monday or Wednesday, my lord. I'll have to move this ex parte because we have received notice from my bank. They've invoked the letter of credit. Goods sold and delivered. They've asked me to short close my contract for me to go ahead and do my risk purchase action. After they've gone and invoked my letter of credit. The money is going to go, my lord. I'll have to move this ex parte. There is no caveat. Kindly allow me to move it day after, either tomorrow.
Serve them.
Then the money will go out. The moment I put them on notice, the money will go. So that one day, your lordship will allow me to move it ex parte. I'll try and keep my LC extended. So that when they come back, but kindly allows it to.
LC expiring.
The LC is going to expire on 13th of February. The money is also probably going to go around that time. Yes, but if I let them know that I'm moving the section 9, they'll cajole the bank into getting the payment out. Give me that 2 minutes time. If your lordship feels it can't be done without ex parte, then I'll serve and come back. But I'll probably be able to show that it will merit a service, an order without service. Consider it's day after tomorrow or tomorrow, any day before Monday, my lord.
Why before Monday? 13th.
13th. Out of equity, 13th, because I.
Keep it on Friday.
Lord, could I just pray for Thursday? Please.
Thursday I have my
Or on Monday.
execution days. Monday.
Monday. अरे एखुनी तो Monday बोल रहे আমাকে Tuesday, my lord. It will still be valid.
Till Tuesday.
Tuesday.
Lordship, I wish to mention. Lordship, I wish to mention there are few execution matters. The execution matters are filed in the year of 2025, and in all matters, the service is duly and properly affected. And I want service order. Kindly, Lordship, this matters keep it on Thursday or Thursday list.
May I have my lord kindly, my lord, to mention an order dated 26th April, my lord. By this order, I was directed to furnish a bank guarantee and withdraw the amount lying on the account of these proceedings with the registrar, my lord. I filed the bank guarantee. My lord, the next date is due to expire on 7th of February. Now, when I went to the department, my lord, I was told to obtain leave from your lordship because by this order, it was directed to renew the bank guarantee before 1 week, 1 month from the date of execution.
An appropriate application, sir.
My lord, my lord,
Not going to be done on oral mentioning.
lordship.
May be permitted to mention item 39 of the monthly list upon notice. My lord, this is a section 9 application. The pleadings are completed. The interim order is expiring tomorrow. So I was humbly seeking if it could become, if it could be.
Granted.
My lord, it was initially granted in April.
What steps have you taken for constitution of the arbitral tribunal?
Lordship, the section 11 is pending for orders before Justice Shampa Sharkar. It is running in the monthly list. It may be taken up today because she takes, the ladyship takes up the monthly list on Tuesdays and Thursdays. It may be taken up today.
My lord, if I may be permitted to mention one matter, my lords, I'm only praying for drawing up and praying for leave for drawing up an order dated November 4, 2025, passed by my lord in an AP Com 673 of 2025.
Lordship, may I be permitted to mention one matter, my lord? My lord, these are 4 analogous matters, my lord, Shrey versus Karur Vaisya Bank. My lord, out of them, the 3 matters are appearing in lordship's daily list. My lord, the parties have settled this matter out of court, my lord. We have filed a formal application to that regard. Lord, we had taken out a master summons also, which is returnable today, my lord. My lord, any day lordship's list, whenever execution matters are taken up, my lord, may be listed, my lord.
Lordship, I wish to mention on execution matters with 34 application. This matter already settled between the parties, and I also served the notice upon the respondents, and they are duly received. Lordship. Lordship, there are few execution matters for withdraw.
My lord, on the last occasion, the award holder was granted 2 weeks' time to supply the fresh address of the award debtors to the department. And unfortunately, the time period has lapsed and we had received the fresh address also. So I'm just praying for 1 week's time to supply the address of the award debtors to the department.
You were supposed to do it in 2 weeks' time.
Yes, my lord. And actually, the address could not be found during that time. So just 1 week's time, my lord.
Mentioned.
Grateful.
On judgment, item number 1.
In view of the aforesaid, the present petition is allowed. Respondent number 1 to 3 are restrained from operating or dealing with the bank account referred to in Annexure H to the present petition, namely Punjab National Bank, IFSC so-and-so, and the other bank. The petition is directed to communicate this judgment to the concerned branch manager of Punjab National Bank. The petition is directed to take immediate steps for the constitution of the arbitral tribunal. The parties are at liberty to seek modification or variation of this judgment before the arbitral tribunal. With the aforesaid direction, the present petition stands allowed.
Lord, in action was prayer E, Lord, the prayer was that they should not be operating the bank account without keeping an aside sum of
Yes,
2 crore
that's
90.
what I've granted.
So that figure, your Lordship has mentioned.
Prayer H.
I'm
Minimum balance of 2 crore 93 lakhs.
grateful, my Lord. It's not a blanket. I'm grateful.
There are 2.
Good. Yes. Color the list.
Mention item number 2.
Lordship, I'm appearing for the award holder in this matter. Lordship, at the cost of admonition and subject to what my lord will instruct, Lordship, I've come up with another rectification small that I've mentioned. My lord, I apologize for the inconvenience caused, Lordship. I apologize. But Lordship, kindly, if Lordship may kindly include them.
Please, what is this? Every
No,
day
no,
we can't do this.
No, Lordship, I humbly apologize, Lordship, for the inconvenience, Lordship. This is as per client's instructions, Lordship.
What do you want now?
Lordship, inclusion of the learned senior advocate, Mrs. Manju Bhuteria, for the award holder in my lord's judgment dated 28th November 2025, Lordship.
This has to stop.
Lordship, this is the last time. Lordship, kindly accepts my apology, Lordship. Kindly.
You have made a mockery of this court.
No, Lordship.
Every day you'll come up with this name is not there, that name is not there. What is this?
Lordship, I understand, Lordship. I apologize,
You're
Lordship.
sitting here only for these corrections.
No.
What, your seniors don't get paid if their names don't figure in the...
No, Lordship.
Take the correction. It's too much.
Lordship, I'm so grateful, Lordship.
At least in one time you should come up with all this.
Great.
And these are judgments which are already passed. And then you ask for these rectifications.
Lordship, I apologize, Lordship, for the inconvenience.
Take down the name of that. Did she even appear?
Lordship, she appeared in the matter, Lordship.
Why it is not reflected?
Lordship, we have given the name inadvertently, it's not appearing, Lordship, in the judgment.
Take the name of the... What's the name?
Learned senior advocate, Mrs. Manju Bhuteria. I have written it in that judgment given yesterday.
Next.
And I appear for the award holder, my lord, I disposed of this execution application on 15th January. My lord, subsequently, there was a small correction is to be made, your lordship, in paragraph 2 of your lordship's order at page 1. My lord, the address of the apartment will be read as Suraiya House, 33/2, Sarod Bose Road, flat number 12, third floor, Bhavanipur, Calcutta, 7,20,000.
An inadvertent error had kept into the order dated so and so. The order stands modified to this extent. Correction.
Great. I'm so grateful, your lordship. Great.
Lordship, in item numbers 4 to 7, Lordship, yesterday we have submitted that item number 4 to 7 as per the client's instruction. We have to withdraw these matters since the assets are not traceable. Thereafter, Lordship has directed for a written instructions from the client. Hence, Lordship, we have instructions over mail.
Somebody else would appear.
Lordship, Ms. Harshita Nath was appearing.
Last court order.
Madam, they are withdrawing it.
I'm withdrawing the matter.
4 to 7. You got your money, right?
No, my lord. Last time, as per court order, they had not got that.
Lordship, we shall pay it. Lordship.
Pay the receipt.
Lordship, we shall
My lord,
comply.
item number 7, please.
Item number
Please
7.
order.
Lordship, we shall comply. Lordship.
Yes.
Comply
Yes,
with
The payment is already processed. Lordship, it shall be
My lord,
disbursed in some time.
Please order.
They'll pay it, madam. She appears every day in this court.
Oh, my lord.
Take down item 3 to 7.
4 to
4
7,
to 7.
Lordship.
For learned counsel for the petitioner seeks to withdraw the present petition. Full stop. The instruction received from her client is taken on record. Full stop. The present petition is dismissed as withdrawn. 4, 5 may be same. 6 same. 7 same. 7 make line add करते ना learned counsel for the petitioner assures this court that the receiver's payment shall be made within 1 week.
Lordship, 2 weeks, Lordship, kindly.
Within 2 weeks. Full stop. Dismissed as withdrawn.
My lord, grateful, my lord.
Dismissed as withdrawn, huh?
Grateful, your Lordship.
All interim order, if any, stands vacated. Submit.
May it please your lordship, my lord. This is my lord, my second application for extension of time of the arbitral tribunal. So my lord, first extension was on May 15, 2025 by the court. Page 40, my lord. Page 40, the last paragraph. Page 40, last paragraph. Now, my lord, within this time, under these circumstances, they seek to extend the mandate of the learned arbiter for a further period of 8 months from the date of communication of this order. Now, my lord, in this period, my lord, the witness action completed. Claimant, I am the claimant. My submission also completed. Now they are giving reply. They are making argument. The respondents, I am going to give reply. So, my lord, 6 months extension will do. As a matter of fact, they also, my lord, by way of an email, has given consent, which is at page 42. Your lordship will find that. They have given consent at page 42 to the arbitrator.
Kindly extend the mandate, my lord.
I think by 6 months it will be.
Whatever you think fit.
Hey, Dakchin.
The petitioner has preferred the present application under section 29A of the Arbitration Conciliation Act, seeking extension of the mandate of the arbitral tribunal. Conclusion of the arbitral proceedings and publication of learned counsel
Affidavit of service
for the petitioner submits that from court by order dated 16/5/2023, appointed a learned sole arbitrator to adjudicate the dispute between the parties. The pleadings were completed on 18/10/2023. Full stop. Thereafter, with the consent of the parties, mandate of the arbitral tribunal was extended further for a period of 6 months. Full stop. While order dated 15/5/2025, this court extended the mandate of the arbitral tribunal by 8 months till 22/12/2025. Full stop. Learned counsel for the petitioner submits that the arbitral proceedings are at an advanced stage. Full stop. Learned counsel for the respondent states that he has no objection to the extension of the mandate of the arbitral tribunal. Full stop. Upon consideration of the materials placed on record, this court is satisfied that no delay in the conduct of the arbitral proceedings is attributable to the learned sole arbitrator. Full stop. Having regard to the advanced stage of the arbitration and in the interest of justice, the mandate of the learned sole arbitrator is extended further for a period of 6 months from today. Full stop. The learned sole arbitrator is requested to conclude arbitral proceedings within the extended time period. Full stop. With the aforesaid direction, the present petition stands disposed.
Great. I am grateful, my lord. Much obliged.
I appear for the respondent.
May it please this honorable court, this is my application under section 29A of the Arbitration and Conciliation Act. May I not file my affidavit of service, my lord?
I'll be candid, my lord. I do not have instructions, and there is a statutory authority, my lord. If your lordship is, my lord, inclined to extend, my lord, kindly, my lord, lordship will make it order of the court. Lordship, kindly not record my concern, my lord.
I just indicate two things, my lord. The arguments are complete.
But 10th is fixed for filing of notes. Sorry.
That's it.
Just filing of the final notes on argument. This is, my lord, my section, second section to application of section 29A.
Which was the first one?
My lord will find it at page 27, my lord. The communication was dated 20th May 2020 to the learned arbitrator, received by the learned arbitrator on the 21st of May. So the mandate was set to expire 8 months therefrom, my lord, which was supposed to end on the 21st of January. I have filed before that. I have filed on the 19th of January.
Arbitrator appointed on 15 December.
Yes, my lord. 15 December 2022, my lord will find that order at page 22. My lord, may I just say this? If my lord is inclined to extend the mandate, could the mandate be extended by a period of 3 months? I shall indicate why. Voluminous pleadings, voluminous examination, works contract, claim, counterclaim, both stretching into a huge documentation, my lord. The learned arbitrator has been nothing but kind to us on each and every single occasion, my lord. You know, in prayer A, I have sought for extension of the mandate for a period of 3 months, my lord.
Take down. First line where you got the petition with the application under section 29A of the Arbitration and Conciliation Act, seeking extension of the mandate of the arbitral tribunal to conclude the proceedings and publish the order. Learned counsel for the petitioner submits that this court, by order dated 15/12/2022, appointed a sole arbitrator to adjudicate the dispute between the parties. Full stop. The pleadings were completed on 19/7/2023. Thereafter, with the consent of the party, the mandate of the tribunal was extended further for a period of 6 months. This court, by order dated 1/5/2025, extended the mandate of the tribunal by 8 months till 21/1/2026. Full stop. Learned, upon consideration, so पहले लिख देना affidavit of services placed on record. Respondent placed on record. Respondent appearance. Upon consideration of the materials placed on record, this court is satisfied that no delay in the conduct of the arbitral proceeding is attributable to the learned sole arbitrator. Having regard to the advanced stage of the proceeding and in the interest of justice, the mandate of the arbitral tribunal is extended further for a period of 3 months from today to enable the learned sole arbitrator to publish the award. First, the sole arbitrator is requested to publish the award within the extended time period. With the aforesaid direction, the present petition stands disposed of.
Obligement.
So you had given your consent in the first order.
That was there, my lord, but today I do not have instructions. That is the only difficulty. The lordship has not recorded my consent. Probably I would have, my lord, but that is my difficulty, my lord.
I've only recorded your
The consequences will be on.
My learned senior friend has a counterclaim.
You know, I do. But
No, my lord, he's creature of instructions.
I'm for the petitioner, your lordship.
I am for the respondent counterclaim.
A.
29A application, your lordship. This is my second 29A application.
Is the first order.
The first order, your lordship, it's at page 10. 15th, 22nd May 2025 order. The extension was for 8 months, your lordship, which expired on 22nd January 2025.
Just a minute. Give it the date. Sorry.
2026. Yeah, sorry. I'm sorry.
Expired on.
Expired on 22nd January 2020.
Arbitrator appointed.
Arbitrator was appointed, your lordship. 11th August 2023, we filed a statement of claim, your lordship.
11th of May 2023.
Yes.
In an application under section 9 in the presence of the parties.
Readings completed on.
Readings completed.
8th of October 2023. First extension, 22nd May 2025 for 12 months, for 8 months.
8 months.
Which got expired on January 22, 2026.
Take down.
Your lordship, we pray for 12 months because a valuer has been appointed and
Partnership dispute,
your
resolution was already awarded. After that, Millard, there has been a receiver appointed who has produced accounts. He is going to be cross-examined. That may take some time. And after that to be followed by arguments and then passing of the award. We leave it to your lordship. It may take some time.
Yes,
leave it to your lordship.
Is there a time frame given in the act?
But the original time frame certainly, Millard, is 18 months.
No, not the original.
After that,
the extension one. It is to the satisfaction of the.
To the satisfaction.
That's
yes.
Yes, your lordship.
In first paragraph of present application has been filed under section. Learned counsel for the petitioner states that this court-wide order dated 11/5/2023 had appointed a sole arbitrator to adjudicate the dispute between the parties. Full stop. The pleadings were completed on 8/10/2023. Full stop. Thereafter, with the consent of the parties, the mandate of the arbitral tribunal was further extended for a period of 6 months. Full stop. Thereafter, this court-wide order dated 22nd May 2025 extended the mandate of the arbitral tribunal by 8 months till 22/1/2026. Full stop. Learned counsel for the respondent states that he has no objection.
Because I have a counterclaim.
He has no objection to the present application. Full stop. Upon consideration of the materials placed on record, this court is satisfied that no delay in the conduct of the arbitral proceedings is attributable to the learned sole arbitrator, full stop. Having regard to the advanced stage of the arbitration and in the interest of justice, the mandate of the arbitral tribunal is further extended for a period of 8 months.
Yes.
8 months from today, full stop. The learned sole arbitrator is requested to conclude the arbitral proceedings and publish the award within the extended time period, full stop. With the aforesaid observation, the present petition stands disposed of.
Deep love.
Aforesaid direction. The aforesaid direction of the present petition stands.
Petition 9, item number 7.
For the petitioner, my lord, there has been a non-compliance of your honorable's court order, my lord. My lord, I have nothing more to submit as the officer of the court, my lord. I leave it up to your lordship because we have been enjoying an injunction. Pursuant to that, my lord, there has been a direction for the leave was granted by this honorable court. Means the receiver is appointed. Subsequently, your lordship has granted leave to communicate to the receiver. But my lord, I am being very candid, my lord. That there is none regarding from the client's end. There has been a lot of dereliction on the part of the client, my lord. Right now, my lord, I cannot better my case or make any submissions which means which will
do.
my lord. This is the my lord. My lord, as officer of the court, my lord, I think, my lord, means for the non-compliance, my lord, I should be means our client should be should face the music for this, my lord. As an officer of the court, my lord, I'm making this submission, my lord, because I have been taking your lordship was kind enough even to grant me adjournment, my lord. But so means we have means from our end, my lord, we have made the due communication to the client, my lord, but subsequent to that, there has been no proper correspondence, my lord. I cannot better my case, my lord, going by the conduct of the client, my lord.
But you are responsible for the conduct of your client.
But we have on 25th August 2025, we have got the injunction order.
Yes.
Pursuant to that, on December, my lord, your lordship was pleased to appoint the receiver. Pursuant to that, my lord, your means on 5th of January, a leave was granted to issue notice to the receiver. But right now, my lord, my hands are tied because without the means I cannot better my case, my lord, at this stage, my lord. Making any submissions.
If you don't appear, I'll dismiss in default. Don't enter your appearance.
Well, the difficulties, my lord, is, my lord, right after making those things are getting extreme, my lord. So this is the difficulty now, my lord.
Since you are not receiving any instruction from the client.
No, receiving instruction, my lord. They have not also initiated the arbitration also, my lord. This part only we are ready with the section 11 also. Actually, what happened in the midway, the concern, but this cannot be another excuse of the authorized representative. He lost his mother, then he is also currently in a medical leave. These are the issues. But for a company that authorized representative is in a not in a proper stage, cannot be a ground to pay before your lordship for adjournment time and again, my lord. Only on the last occasion, what I've got to know, but that the consent inventory that needs
I'll give you one more opportunity for being so candid. Try to get the instruction from your client.
Well, my lord, then kindly mention as last chance, my lord, okay. So that
I don't want you to lose your client also.
But for fortnight time, for the last time, as a last chance, my lord, kindly make.
Then it comes with the petitioner, seeks and is granted 4 weeks time to comply with the orders passed by this court. With the directions issued by this court, by order dated 1st December 2025 and 5th January 2020.
Well, I tender my apology. Last occasion, my junior appeared. She got a bit nervous, my lord, because she has just started her journey in Calcutta High Court for the last 3 or 4 months. In fact, this is the second matter that she has missed. So that is why I tender my apology for that. Well, I got little late in appearing.
If I record anything more than this, you'll lose your client.
Well, but I also do not also embrace the court also, my lord, because I am a
It's good to be the officer of the court first, and then
my lord, I understand.
I appreciate that.
I'm grateful, lord.
Best after 4 weeks.
Lordship, I'm for the petitioner. And
Lordship, I'm actually praying for a short passover, my lord. For
I'm praying for 2 weeks adjournment to file and reply, Lordship.
What is the case?
Lordship, earlier an order was passed for interim order. It was passed 6 weeks. We have interim order, Lordship, to not sell the vehicle, and vehicle is in the custody of the respondent's Lordship. And we have been directed to file the dues installments to receive back the vehicle, Lordship. And on 21st January 2020,
Wanted to file your affidavit in opposition?
they have filed on 21st
Yes.
January, Lordship. I'm seeking 2 weeks time to file reply, Lordship.
Learned counsel for the petitioner seeks 2 weeks time. Seeks and is granted 2 weeks time to file a reply to the affidavit in opposition filed by the respondent. Placed after 4 weeks. Yes.
Lordship 13 on behalf of the petitioner. Lordship, on last occasion, Lordship was pleased to appoint a receiver on this instant matter for taking possession of the vehicle. However, Your Lordship, the vehicle cannot be traced as of yet. Lordship may makes the matter go out of the list with liberty to mention, Your Lordship. Or Your Lordship may keep the matter after 4 to 6 weeks, Your Lordship. In the meanwhile, we'll start tracing the vehicle.
Learned counsel for the petitioner states that seeks and is granted. Learned counsel for the petitioner states that the vehicle could not be located. He seeks and is granted time to locate the vehicle. Let this matter go out of the list with liberty to mention.
Right, Your Lordship.
In these kind of matters, you should withdraw it if you're not able to find the vehicle.
Lordship, there was a direction of Your Lordship to file a report of the receiver, Your Lordship. The receiver was appointed, Your Lordship. If I withdraw the matter, Your Lordship, the receiver stand.
Receiver, have you paid the receiver?
We have made necessary communication to the receiver, Your Lordship. We are in receipt that we are, all are searching the vehicle, Your Lordship. We cannot. Even the finance company is searching the vehicle. Oblige, Your Lordship.
My lord, this is, my lord, a contempt petition.
Yes,
My lord, for violation of, my lord, the arbitral tribunal's order. I am told, my lord, the service is
not done.
I mean, it's done, but it's done, but from our end, but my lord, the receipt, my lord, is not reflecting.
That has to come.
But item
But my lord, item 22, my lord, is their appeal, my lord, under section 37 against, my lord, the same order.
They are there. Show item 22 on
They are
the board.
aware of this, my lord.
Item 22. Board pe dikhai.
Because the advocates have been served who are appearing in the arbitration.
See if he comes.
Yes, my lord.
Now we'll take it up with item 22.
Very well.
Chhod do. Pass over. We'll take it up with 22.
Grateful, my lord.
Yes.
My lord, I appear for the petitioners.
appear for the award holder. This is section 36.
My lord, actually, these are two matters. One is under section 36 and the other is section 34. Section 36 application was moved before the coordinate bench earlier, and there was a direction for filing of affidavits. Those are complete. Should I place the section 36 first? Section 36. This is relating to my lord an award.
So 36, you wanted unconditional stay. That's what it is.
Yes, yes. And that is why.
They have filed their reply.
Yes, they
Yes,
have
my
given.
lord.
Affidavit of
We have given our
Yes.
reply. Affidavits are complete.
They filed a reply today.
So should I place the my lord?
They have not used a reply, my lord. What we
I
call
am.
in Calcutta.
My file. I find reply. I don't know
I
whether
don't
it is.
think we have been served. Perhaps we've not been
Okay,
served.
the letter.
This is my
Oh, sorry, my lord.
observation.
This is just now handed over to me. This has been affirmed. Has not been served.
Has not been served, perhaps. Service.
You have to give a copy.
No.
But on the 36 issue, my lord, perhaps affidavits were directed, but 36, your lordships are aware, it's a very limited scope now. Very limited scope, and there are judgments of the coordinate bench of our court. And
This is my petition.
Yes,
You should take.
Yes. To serve a copy, Mr.
I have served.
sir, he's handed over now, my lord. Let him place his application on bench, whatever, if he wants to.
And 34, the award is of which year?
2019, please, my lord.
2019.
Yes, please.
So we can hear the 34.
This was put to execution before Bombay High Court, and that warrants us to file this application under section 36 here. The questions are, my lord.
We can hear the 34 also, Mr.
Sir, kindly allow me to place 36 first, because this was on exchange of affidavit. This is complete now. Now this is, my lord. Actually, your lordship, if you'll kindly come. The questions raised in this section 36 applications are that whether, if your lordship kindly finds who are the respondents, and who are the applicants. The Additional Commissioner of Customs, Disposal General, Auction Unit, having his office at New Customs House, Ballard Estate, Mumbai. This is the applicant before your lordship against two respondents. One is Mittal Continental, who is the award holder, and this is the pro forma respondent, MSTC. Now, my lord, the first point we have taken here is that whether in a proceeding, either for arbitration or any other proceeding, whether the Additional Commissioner of Customs can be sued, who is representing Government of India under the Customs Act and the Constitution and also the Civil Procedure Code, whether Union of India is a necessary party or not. The Union of India has not been made a necessary party, and my lord, actually, this point was taken and it was to be addressed to your lordship first, whether this actually, if your lordship kindly come to the issues at page 56, one is in the list, page 56 of the petition. Issue number 1 towards the bottom, whether the claim filed is within the period of limitation. We have taken an additional point of limitation also. The respondent number 1 contended that the claims of the claimant are barred by limitation, as the claim made by the claimant was on 12 January 2016, and that delivery order was issued on 13th August 2012. Therefore, more than 3 years, 6 months, this has been filed. It was also contended by respondent number 2 that claims are barred by limitation since the payment in respect of subject goods was done on 26th of July 2012, and so the cause of action, if any, arose on 26th July 2012. The respondent number 2 further contended that limitation once started cannot be stopped by mere exchange of correspondence, and in support of their contention relied on such and such. Your lordship is aware that under section 3 of the Limitation Act from 1963.
Those are the merits of the matter, sir.
No, merits of the matter. I'm counting. If it is.
We are talking about 36 too.
36, but 36 too, there are two questions. Whether if.
That is the reason I said
if it is barred by limitation, it's a nullity. Award is a nullity.
That is the reason why I asked that, sir, you argue on the merit of the matter.
I shall come to that. But these are also the merit of the matter.
36.2, I can't go into the merit of the matter to that extent, which I can go in 34.
Yes, that's true. That's true. I appreciate it. That's true.
That's
But the other point, my lord, which is substantial, we have raised that whether the arbitrator had a jurisdiction to proceed with the additional commissioner of customs and pass the award against the additional commissioner of customs, which is not enforceable at all, because the law enjoins the jurisdiction to sue and to be sued to the Union of India and not to the
Can I look into these aspects? In a
prima facie, if your lordship wants to grant a stay, injunction, or stay of the further proceeding of execution, these are matters to be addressed.
These are matters.
Because if it's fraud or jurisdictional question or nullity, these are matters. So if an award is passed without making the Union of India a party in respect of certain award and some amount, whether it is a nullity. And if it is a nullity, if your lordship holds, then automatically 36 comes into play in grant of injunction. Therefore, this is the only thing I'll be addressing your lordship, that your lordship will kindly come to the next and this was detailed discussion on the question of limitation. Now kindly skip over and come to issue number 2. Whether the arbitral tribunal has the jurisdiction to decide upon the claim against the respondents. Both the respondent number 1 and 2, as page 58, towards the top. Both the respondent number 1 and 2 had filed separate applications for striking of their name as a party to the present arbitration proceedings. Vide order number such and such of this tribunal, their applications were rejected since found without any merit. The action of the respondents caused considerable delay as well as in finalizing the arbitral proceedings. Therefore, this issue, very much issue of deleting the name or striking of the name of the additional commissioner and also the MSTC, and also the MSTC Limited, this prayer was rejected and the learned arbitrator went on with the question of grant of award. So this is a very question, my lord, I am submitting before your lordship, that whether a proceeding can be initiated against the additional commissioner. He has, if any, jurisdiction to represent the commissioner of customs, but not Union of India, unless Union of India is sued and is not given notice, then, my lord, this entire proceeding is a nullity. That is the question we have, my lord, seriously argued in this 36 application, that if the award is a nullity without service of notice. Now I'll be placing before your lordship first the question of although there I shall be placing the agreement also there, which enjoins the liability to serve the notice to the government of India. I will be placing that later on. Kindly come to the section 79 of the Code of Civil Procedure.
Section?
No, section 79, may I read? Of the Civil Procedure Code. Suits by or against government. In a suit or in a suit by or against the government, the authority to be named as plaintiff or defendant, as the case may be, shall be A. In the case of suit by against the central government, the Union of India. The Civil Procedure Code, which is the basic guideline for adjudication of all civil matters, even if the Civil Procedure Code does not apply in arbitration proceedings, but the principles shall apply. Therefore, Section 79 enjoins the jurisdiction and right to the arbitrator to give notice to the Union of India for proceeding with the arbitration case. This was not done. Section 79 is a bar. Then kindly come to Section 155 of the Customs Act, which is also very relevant. Section 155.
Customs Act.
Section 155 of the.
We have another copy.
মামলা করা যায় তোমার কাছে নেই? Lord, I am handing over my copy to your lordship.
It's okay.
Kindly see the protection of action taken under this act, section 155 of the Customs Act.
Protection of action taken under the
Yes,
act.
yes.
I am.
May I just read once for your lordship? This is
Yes,
155.
no suit, prosecution, or other legal
No suit,
proceedings.
prosecution, or other legal proceedings. Other legal proceedings I have covered here shall lie against the central government or any officer of the government or a local authority for anything which is done or intended to be done in good faith in pursuance of the act or the rules or regulations. No proceeding other than a suit shall be commenced against the central government or any officer of the government or a local authority for anything purported to be done in pursuance of this act without giving central government or such officer a month's previous notice in writing to the intended proceedings and of the cause thereof, or after the expiration of 3 months from the accrual of such cause. Therefore, it is an obligation that nothing shall proceed without giving notice to the central government.
Sir, as far as the Arbitration Act is concerned, it's a separate legislation also.
That's true, but Arbitration Act does not.
If it is arising out of a contract between two parties and customs is a party there, show me the contract first.
Yes, I shall come to that. Before that, my lord, kindly allow me to place Article 300 of the Constitution.
What is the awarded amount?
147 crores. My lord, Article 300 says of the Constitution, suits and proceedings, the government of India may sue or be sued by the name of the Union of India, and the government of a state may sue or be sued by the name of the state, and may, subject to any provisions which may be made by the Act of Parliament or any of the legislature of such state, enacted by virtue of powers conferred by this Constitution, sue or be sued in relation to the respective affairs in the like cases as the Dominion of India and the corresponding provinces of the corresponding Indian states might have sued or been sued if this Constitution had not been enacted. So even if arbitration proceeding is a separate proceeding, whether the obligation is there, whether the additional commissioner of customs, that even not the commissioner of customs made a party. And again, a proceeding was initiated against the additional commissioner of customs. What liability he has? He has acted on behalf of the customs authorities in a proceeding. Now, if it is to be an arbitration award has to be passed, it is a liability and execution. All these things come when such questions are falling within the jurisdiction of the arbitrator to give notice. Now, lordship has rightly pointed out, the agreement has to be looked into. Kindly come to section 34 application.
34 petition?
Yes, 34 petition. My learned friend wants me to file one supplementary affidavit which has been served.
Yes.
Served with the losses leave. Supplementary in connection with section 34. With the losses leave. Kindly come to
There in
section.
the supplementary affidavit?
This is
other points which has been left open in the section 34 application. All points have been covered there. Regarding not making the Union of India a party, right from the appointment of arbitrator, also before the extension of arbitration
award.
when it was out of time after 1 year, my lord, they made the application against the commissioner only, not make the Union of India as a party.
Has your lawsuit got section 34 application?
No, which page is that?
Yes, kindly first come to page 59. Section 34 application, page 59.
59 of the additional affidavit?
No, the original application, 34.
Hey, 34 then I. Gopal. 34. Then what's the point of filing this additional affidavit if you don't even have the agreement in there?
The agreement annexed to the original application.
I am pressing the selling agency agreement now at page 59.
Page 59.
59 of the original application 34. This agreement made on the 28th day of July 2011 between the Commissioner of Customs General, New Customs House, Ballard Estate, Mumbai, hereafter called the Principal on the one part, and MSTC Limited, Government of India enterprise under the Companies Act 1956 and having his registered office at such and such and having his Western region office at such and such. The agreement is being executed by the Commissioner of Customs on behalf of all the Commissioners of Customs under the Central Board of Excise and Customs, New Delhi. Consequently, the concerned commissioners engaging measures MSTC to conduct auction, tender, e-tender for goods to be disposed of in the e-auction will act as principal for that auction. This is an agreement, therefore, my lord, is between the Commissioner of Customs and MSTC that the pro forma respondent at for execution of certain things. Now, kindly come to page 64. দাঁড়াও পরপর করো না page 64 arbitration clause towards the bottom, clause 15. In the event of any dispute or difference relating to the interpretation and or application of the provisions of this agreement, signatured with address, such disputes or difference shall be preferred by either party to the arbitration of one of the arbitrators in the Department of Public Enterprise to be nominated by the Secretary to the Government of India in charge of the Bureau of Public Signature with address, signature such and such. Therefore, this is an agreement not with the claimant, but between the Commissioner of Customs and MSTC. And there is an arbitration clause, and it clearly provides if any dispute arises, that shall be adjudicated by the Public Enterprises Department of the Government or Secretary of the Government of India, not by an arbitration arbitrator. Then kindly come to page 65. Page 65, my lord, is towards the top. This is continuation is from the last page. The Indian Arbitration and Conciliation Act shall not be applicable to the arbitration under this clause. The award of the arbitration shall be binding upon the parties to the dispute, provided, however, any party agreed by such award may make a further reference for setting aside or revision of the award to the Law Secretary, Department of Legal Affairs, from Secretary Public Enterprises to the Law Secretary. This is the detailed guideline in the agreement. The entire proceeding and jurisdiction taken over by the arbitrator is a nullity. Then kindly come to the applicability of laws. The agreement shall be governed by the signature with the address Indian laws for the time being in force, except the Arbitration and Conciliation Act 1996, in case of arbitration arising out of disputes, differences in connection with this agreement. And this agreement was signed, my lord, kindly find towards the bottom left-hand side, signature with address for and on behalf of the President of India. This is executed by. So how can the commissioner, additional commissioner of customs be made a party in an arbitration proceeding and award can be passed? This is a lawsuit has seen for and on behalf of the President of India. And this is under Article 299 of the Constitution.
Did you raise all this before the arbitrator?
Yes. I'm coming to that. I'm coming to that later on. Kindly come to para 23 onwards of 34 application. Page 23, para 23. Subsequent thereto, the respondent by his letter dated such and such again, just to delay the delivery of the consignment goods, requested the petitioner to set aside the Central Warehouse Corporation charges, knowing very well that in terms of the agreement, the respondent number 1 is liable to pay such charges. In the event they fail to take delivery of the goods within the stipulated time of 7 days, a photostat copy. Then 24. The respondent number 1 again by his letter dated such and such wrongfully and illegally claimed that they have not received any delivery order and requested the petitioner to issue afresh. In response, the petitioner by his letter dated these are matters, my lord, I kindly skip over and kindly come to page 33. Page 33 and 48. Page 33. Clause D. The petitioner also argued that there was no arbitration agreement between the petitioner and the respondent number 1, and the arbitral agreement was between respondent number 1 and the respondent number 2 only. The learned arbitrator dismissed such contention of the petitioner and wrongfully observed that though there was no direct agreement between the claimant and the petitioner, but the respondent number 2 was only the face of process, being an auctioning agency, and the petitioner being the principal, could not be struck off from the arbitration proceeding. So this is also absolutely without jurisdiction. If the Arbitration Act does not apply, the proceedings are to be initiated before the Public Enterprise Secretary and then before the Law Secretary, and the agreement is signed by on behalf of the President of India under Article 299. How can the additional commissioner be made a party in such a proceeding and the arbitrator has proceeded? Even if that is not raised, it was the duty of the arbitrator to find out the law and decide the issue. How the award shall be enforceable? And even if Miller Arbitration Act is taken into consideration, this is absolutely arising out of an agreement. Appointment of arbitrator, proceeding by the arbitrator, and passing of the award. Without there is no agreement, there is no arbitration. Now kindly come, my lord, to the some of the grounds we have taken in 34 at page 46. This is finding of the arbitrator is contrary to the materials on record. Arbitrator suffers from patent illegality and is conflict with the public policy. Then there was no documents or pleadings on record which the learned arbitrator tribunal could have passed the SIB's impugned award. Then, my lord, kindly come to page 48. The Central Warehouse Corporation, 47, ground number 11. That the learned arbitrator failed to consider that the communication dated 20 February 2014 issued by the Deputy Commissioner of Customs Disposal allowed delivery of goods in favor of the respondent 1 upon payment of charges. Then kindly come to waiving warehouse charges by the customs, since the Central Warehouse Corporation is a separate agency and the customs has no authority to charge or waive their charges. Then ground number 16, for that the learned arbitrator wrongly came to a conclusion that respondent 1, being the petitioner herein, had not been able to establish the delivery of the delivery released order dated 13th August 2012. Therefore, my lord, kindly allow me to place the merit of this section 34 application. The general terms and conditions of e-auction. These are MSTC Limited, page 66. This is condition of goods and all agreements. These are entirely entered upon. Therefore, first submission I am formulating that it is well settled law that unless the award is a nullity or is obtained by practicing fraud or jurisdictional error, the court has very limited scope to interfere. Now, it is on the basis of that a very initial stage, it appears to your lordship that it is wholly without jurisdiction, is a nullity. There is no agreement between the claimant and the customs authority, and there was even if a dispute arises between the pro forma respondent and the customs authority, reference shall be made to the public secretary, public enterprise, and then to the law secretary, and that Arbitration Act does not apply in the agreement it is provided. Whether how is it that the arbitration proceeding went on and the award was passed? That apart, my lord, your lordship has seen that the agreement was signed on behalf of the President of India. No agreement can be signed under Article 299 of the Constitution unless Union of India is made a party. And all agreements are entered into by and between the parties and the Union of India. Kindly allow me to place once in the list Article 299 of the Constitution. contracts. All contracts made in the exercise of the executive power of the union or the state shall be expressed to be made by the president or by the governor. The entire proceeding, my lord, is a nullity.
Yes.
Now kindly come to some of the findings of the learned arbitrator. This your lawsuit, kindly find the arbitral award page 11 of the section 96 application. It has been annexed. Clause. I should take your lawsuit stated to the issues, whether the issues were page 56 onwards. This page 45, which was recorded by the learned arbitrator about the question of limitation. Then, my lord, 56 onwards are findings relating to issue number 1 within the scope of limitation. The arbitrator says that the cause of action arose thereafter and within the period of 3 years. Page number 57. This is the finding of the arbitrator. Towards the bottom of 57, after considering the submissions, pleadings, and the arguments, it leaves no doubt that the cause of action could not have been arisen before 25th February 2014. Where from did he get this date? It is a specific case of the proceeding initiated by the respondent number 1, additional commissioner, that your loss will kindly find from the first page of 56. The respondent 1 contended that the claims of the claimant are barred by limitation as the claim made by the claimant was on 12 January 26. How can they overcome this date, 12 January 2016? And that delivery order was issued on 13th August 2012. Clearly more than 3 years and 6 months. Now, where from the learned arbitrator got this date? His conclusion is, and this towards page 57, the claimant has contended that delivery order was not issued to them on the line as per our agreed terms, and that there was no documents to title goods, and hence it was precluded from taking delivery of the goods, and that neither the respondents discharged their duties and obligations in accordance with section 22 of the Sale of Goods Act, nor did they put the goods in possession of the claimant in accordance with section 33 of the Sale of Goods Act. It was contended by the claimant that the cause of action arose on 25th February 2014 when the respondent number 1 refused to waive of the CWC charges. This is not a date of a notice of their knowledge. Then kindly come to the next issue, issue number 2. Issue number 2, for striking off their names as party to the present arbitration proceeding. Both the Additional Commissioner of Customs and the MSTC filed this application before the arbitral tribunal, whether the arbitral tribunal has the jurisdiction to decide upon the claim that he has answered in favor of the claimant. Quite erroneously. Under what consideration we do not know. The sale will be governed by the material list and special terms and conditions STC displayed on the live floor and not under forthcoming auctions, as well as the general terms and conditions and buyer specific terms or conditions already accepted by the bidder at the time of registration with the MSTC. These are other matters which do not come for part of the record of the agreement, and the learned arbitrator went beyond his jurisdiction and kindly come to arbitration. Any dispute arising in connection with the interpretation of implementation of 3 terms of the conditions shall be resolved by arbitration under the Arbitration Constitution Act 1996. Arbitration legal jurisdiction, this is page 60, I am reading. It was contended by the claimant that the respondent had taken part in the proceedings and only challenged the jurisdiction of courts at Bombay and stressed that courts in Calcutta would have the jurisdiction, and thus the challenge was only with regard to the court of jurisdiction, not the jurisdiction of the arbitration tribunal. The issue of the jurisdiction of the court was discussed and decided without any dissent that courts at Calcutta will have the jurisdiction. The claimants further contended that it had established in its relation with respondent number 2, and thereafter respondent number 2 established relation with respondent number 1, and therefore it was a joint contract in which arbitration clause affects all parties involved in a single transaction. This is unheard of. Went beyond the agreement, beyond questions, on his own giving reasons, after taking into consideration towards the bottom, my lord, after taking into consideration the views of both sides as well as the various actions, citation, judgment, I find that the contention of the respondent number 1, that this tribunal has no jurisdiction as against respondent number 1, is without any merits whatsoever. This finding is a nullity. Even if the tribunal has a jurisdiction under the respondent number 1, that is Additional Commissioner of Customs, he ought to have served a notice to the...
You argue at 34.
No, 34.
Argue at 34.
Yes.
Let's finish 34.
T4 is coming up for the first time today. Perhaps the records are not complete.
Complete the records. Let's hear the 34.
Yes.
We'll hear it, Mr. Chakra.
On the 36, my lord, if I may address your lordship, because if he's pressing his 30, your lordship inquired whether he's going to argue the 34 or the 36. My learned friend,
Let's hear 34. We'll finish it off.
Please.
We'll finish off, Mr. Chakra.
No, 34, kindly give us any date. I will be pressing
Keep it 24th of February or 25th of February. You pick a date. We'll finish it. We'll fix a time. We'll finish it. You file a convenience compilation set before bringing on record the entire documents within 2 weeks. We'll keep it for hearing on 24th, 25th.
25th.
Subject to your convenience.
25th.
25th at 2 p.m.
Friday is more convenient for because Friday.
Let's not keep Friday.
Not possible. We'll put your 25th.
25th. Let's keep it on 25th.
25th.
We'll fix a time.
2 p.m. 2 p.m.
2 p.m. on 25th.
Only one point I'll be submitting, subject to what your lordship will say, that whenever the
Mr.
question of...
Chakravarti, I have heard you. I understand. Let's finish it on 20th.
Very well.
All right. We'll do it on 25th. Whatever is left, we'll do it on 26th. We'll try to finish it off.
I shall give the compilation also.
Yes, both the parties take down. In item 34, the parties are directed to file a joint convenience compilation set, bringing on record the entire arbitral proceedings within a period of 2 weeks. Let this matter be listed for hearing on 25th of February at 2 p.m.
May I make one prayer?
Yes.
Because they shall not proceed with the execution in the meantime.
Execution is going on?
Yes, my lord. It's going on. I can address on the 36, my lord, whatever my learned friend has argued. I can address on the 36.
No,
It's
if
been
you're
pending since 2019. They've come now.
No, my lord, if the
when is the execution listed?
I am not aware, my lord, because it's
execution was listed. Execution was listed
before me only.
Not before your lordship.
No. I tell your lordship.
Well, may I just add, if your lordship?
I tell your lordship.
To...
I am telling your lordship that when it was moved before Honorable Justice Sampa Sarkar, 36, there also it was apprised to her lordship that execution proceeding is going on. And on this admission of section 30,
complete your lordship. If
Mr. Please wait. When additional solicitor is addressing, please wait.
I'm addressing the
just hold on. Yes.
I submitted before his lordship that execution is going on. And since it was admitted, the execution case was deferred. But now again it has been listed, I'm told, sometimes in
there is no such order on record. There is no such
kindly record. In the meantime, I'm not praying for an indefinite period.
When is your execution?
I'm not aware, my lord, because it's not before this honorable court. It's being handled by some lawyers in Bombay. Its proceeding is before the Bombay High Court. The execution was filed in 2019, which it appears from his application itself. Kindly see section 36 application. The execution.
Then I'll hear 36. Let me hear 36.
Yes, lordship will kindly hear 36. My lord, if my learned friend is pressing is 36.
Any further submission on 36?
Yes, 36. I have no further submission. I have already submitted. That 36. Oh, he wants to rely on certain judgments.
Yes. Give the judge.
Ashe. He is not ready today, my lord. That is the difference.
We'll have it tomorrow. When do you want? Not tomorrow is Wednesday. We'll have it tomorrow.
Thursday.
Thursday is my execution days, Mr. Chakravarti. Have it tomorrow or
any date your lordship's board permits, my lord.
Tomorrow I have some matters in before court number 1 because public interest litigation matters are next week on Monday. Next Monday.
Next week I have
not proceeded the execution.
No, I am just praying for your lordship has fixed on 25th February. Till 25th they shall not proceed. I am not asking for beyond.
I have to pass an order under 36 too.
Yes. Then kindly go place it on Monday next month. 9th. Oh, 9th আমার এখানে আছে 10th. Let it be 10th.
You do it before that, Mr. Chakravarti. I have
Friday, my lord, has difficulty. For 6th February?
6th February will not take more than half an hour.
We shall not take more than half an hour.
All right. 6th February. How much time will you take?
Depending on what authorities they cite, my lord, I'll just have to deal with them and satisfy your lordship that there's no case made out under 36. The arguments which have been advanced with the greatest of respect are beyond the scope of 36.
Tomorrow, second half of it. He is appearing for the customs authorities. Let you, all of us will be convenient if your lordship kindly places it on 10th at 12.
I might not be there.
He will be in the circuit bench. Lordship will be in the circuit bench.
I might.
Very well, my lord, kindly keep it on 6th. No problem. 6th at 2 p.m.
All right, let it be on 10th.
10th.
Heard. Learned ASG. Mr. Chakravarti. Keep it for further hearing on 10th.
My lord, in the 34, your lordship has directed parties to file a
Then we'll keep both. Both the matters now we are keeping it
my lord, in the
order hata dena.
In the section 34, my lord has been pleased to direct the parties to file a convenience compilation. May I humbly request, my lord, that let them file a convenience compilation. If anything is missing, we'll file a supplementary. Because otherwise, there'll be 2 convenience compilations, my lord.
So you can jointly file it. Didn't you hear my directions?
Your lordship perhaps did not.
Share?
Your lordship perhaps did not share.
I said jointly.
Very. Then the attorneys will, my lord, do
a joint compilation.
Settle the index and file. Very.
34, keep it on 25th of February. 36 too. You keep it on that. Let the order be there. Joint compilation set within a period of 2 weeks.
Joint compilation.
List on 25th.
Argument
and as far as this is concerned, 36 too. You keep it on 10th. Heard Mr. London ASG, Mr. Chakravarti, listed for further hearing on 10th. Why are you filing this supplementary affidavit?
Supplementary addition
in 36 too?
34, man.
In 34? All right. Supplementary affidavit filed. You have got a copy?
Yes, madam, we've got a copy, but we have an issue on limitation. Subject to objections, madam, we'll raise an issue of limitation because additional grounds cannot perhaps be
additional. Are you taking additional grounds?
Nothing.
What is
then what is the supplementary?
No, I shall produce a judgment of the Supreme Court.
Legal points you can argue.
Yes.
Why are you filing this?
No. Actually, these are to be brought to the notice of the Honorable Court legal point we can argue at any stage of the proceeding. I shall be
That's
proceeding
right.
with the
That's what,
Supreme Court
that's what I
judgment.
said. Chakravarti, that's exactly what has fallen from this
Yes,
court also.
yes.
That legal point you can raise at any point of time.
No,
What
there
is
are some matters for constitution of the
No,
facts.
I'm asking a different question. I'm asking you, why are you filing the additional affidavit? What is the supplementary affidavit?
Supplementary affidavit
What are you
discloses.
bringing on record?
Yes.
Anything which is not part of the arbitral tribunal, I'm not going to take it.
Because my lord, when the time limit for my lord, publishing the award was expired,
Yes.
that facts were not before in the 34 application, my lord, and apart from your section all.
See, sir, anything which is not before the tribunal,
We shall not agitate that.
I am not taking it.
My lord, see the question, my lord, when the time limit of the publishing award was expired, they got the order, that the order of the court, my lord, that we want to rely upon, and other sections which my learned additional.
He means to say
Sections, if at all this court requires your written arguments, we'll take it along with your authorities, but not this additional affidavit at this stage.
My lord, this affidavit they received long back.
Maybe, but I'm not
It
saying.
is in whisper, my lord. Can you appreciate, my lord?
No, your lordship will decide that issue on the next date.
It has never been sought to be
I
filed.
taken on record, my lord.
Very well. Question of limitation, we shall argue. We shall give you lordship judgments.
I'm not taking it on record. If this is anything beyond the pleadings.
Not that, my lord.
My lord, may I just submit one thing? তুমি চুপ করো না।
Yes, Mr.
If, my lord, the 34 application is filed within time with certain grounds, are you precluded from filing additional grounds in law?
No,
And whether this additional ground is bar by limitation. For the first time in 47 years practice.
I'm not talking about additional ground, Mr. Chakravarti. I'm only saying what is this additional affidavit. If it is anything beyond the pleading.
We shall not argue that. I assure your lordship.
We will not take it.
No, I shall not argue that at all. I shall argue whatever that is on pleading. And kindly take it on that next day, the additional affidavit, whether it is admissible or not.
All right. Additional affidavit filed by the petitioner is taken on record. Full stop. Learned counsel for the respondent states that. What is the objection?
My lord, the objections are that this is beyond the pleadings, and
States that the additional affidavit contains averments beyond the pleading. Full stop. This aspect, whether the additional affidavit can be admitted, it is this court is of the view that the additional affidavit filed by the petitioner shall not contain any documents which were not part of the pleadings before the sole arbitrator. This aspect will be considered on the next date.
And
full stop.
My lord has been pleased to limit it only to documents. Your lordship would kindly clarify that the pleadings in the supplementary should also not be beyond the pleadings in the arbitration. Because, my lord, if he's trying
what I have stated,
the lordship's have said documents should not contain.
Pleadings. No, pleadings, sir. If the pleadings are concerning any law point, it can be taken at any stage.
If it is
any pleading, as far as it legal averments are there, legal pleadings are there, it can be taken at any stage.
If they've not been taken
Whether
to the arbitrator and being sought
it can
for,
be taken at any stage if it is relevant.
Very well. I'll try to satisfy your lordship on that.
Argument law. How can you say that you have not argued this? You are arguing this only. It can be taken any. Court can appreciate legal pleadings at any stage.
Very well.
36 में क्या क्या है? Opposition filed by the 36(2) में affidavit in opposition filed by the respondent is taken on record. A reply to the said opposition is also taken on record. 36(2).
So on 10th, lordship is not fixing any time.
No, not fixing.
Grateful one.
Grateful.
70.
My lord, in this matter, my lord, your lordship had permitted the state, my lord, to file an affidavit. My lord, I'm out of time, my lord. My lord, the deponent, my lord, my lord, mother was critically ill, my lord. I have the documents. My lord, I can, my lord, file it by Monday, my lord. Your lordship may keep it any day thereafter.
This is, my lord, only relating to further interest which has accrued on the award that they have to put in as security. But I don't know, my lord, what affidavit will come because the amounts are all crystallized. At the most, my learned friend could have given us a chart on the.
My lord, we have, my lord, already, my lord, secured once and they've withdrawn, my lord.
Yes,
After
yes,
considering
yes,
that,
yes.
your lordship gave affidavit directions.
But this legal issue was raised before this court in another matter against the state. Whether after part deposit has been made, there can be an application for requiring the award debtor to put in further amount of security. It was argued threadbare by the then government pleader. And it has been decided in favor of the award holder that the award carries interest along with it. And an executing court or a 36 court is empowered to modify the condition of stay for balancing the equities of the parties. You may have deposited a substantial amount. With the passage of time, that security has become inadequate for the purpose of balancing the equities.
No, but then the security would be earning interest too.
No. Yes, the security has been permitted to be withdrawn also by way of a bank guarantee.
So they've withdrawn the money and then they're saying that further amount is accrued, you have to pay.
Yes.
That's not something which can. I mean, prima facie, I'm of the view that that is like burdening the award debtor.
It is not, my lord, question of burdening, my lord. You have.
Suppose there's an award of 100 rupees. All right, there's an interest, whatever 18%. He has given you the entire amount. You have withdrawn it, right? Then
with a counterbank guarantee.
With a counterbank guarantee.
Yes, with a counterbank guarantee.
Protecting him to the extent that if you lose in 34, that reverses back.
Yes.
But then, as far as that amount is concerned, that can't really accumulate interest again and again, and more money can be given to you.
So that is what will happen.
It's a quantified amount which is there.
But I'll show your lordship the judgment also.
This is
yes, Lord.
I'm not expressing any opinion, but I'm of the view that if it's a
only by quantified
amount, interest has already been earned.
No, that is up to a particular date.
That's right.
Yes.
But then the money has come to you. Now the interest which is going to be accruing is you are also using the money. How you are using the money, interest is being earned on that.
But kindly see the entire amount.
I can't say that the interest will keep on accumulating and you keep on getting the interest on the amount which is not even there. It is like, he is again putting it in the FDR, you're earning it.
No, but it is not.
Well, we'll see that.
Very well.
Lord, by Monday I shall file the opposition. Lord.
We'll see that. I'm not rejecting that argument, but I'm just saying that sounds little.
I'll show your lordship, my lord, that all these points have been gone into and they have tested it before the Supreme Court also.
Lord, very well. My lord, I'm not wasting your lordship's time today, my lord, because in this matter there's an order of Supreme Court, where Supreme Court quantified the amount to be taken by them. So we
Learned Counsel, you have got some money. Learned Counsel for the respondent seeks and is granted further time of 1 week.
1 week.
1 week to file affidavit in opposition. Reply to the same, if any, within 1 week thereafter. List after 2 weeks. 24th February. 21, Mr. Sinha.
24th February. Very well.
You want in March? 21.
No, 24th February is fine. No, 24th February is fine. Yes. I was not there on 19th and 20th. No, that was what I was concerned. 24th February is absolutely fine.
But কাগজটা কোথায়?
Switching sides.
Lord, my flight is not my brief. Somebody said.
Yes, actually এখানেই ছিল তো। 100 টাকা।
But I can borrow my land.
না কেন দেবো? আরে এটা fair হবে। তোমাদের অনেক লেখা আছে তুমি জেনে যাবে সব।
Would Lordship take it tomorrow?
No.
But this is not a formal application, but for not securing the amount, not awarded amount, and not for staying the award.
Lordship, I have a principal objection here.
Yeah.
Yes.
The maintainability ground, Lordship, I will take. Point of completely a point of law.
All right, let him have his brief tomorrow.
Hey,
If you
point of politics.
raise
No, no, no.
maintainability, he has to have his
Yes,
brief.
yes. I completely a point of law, and Lordship will appreciate what I say because
Tomorrow.
I did some sort of a research, and I will apprise your Lordship if subject to what falls from your Lordship. But this is not maintainable.
Not maintainable.
Not
36.
maintainable.
36-2 is
Yeah,
not,
yes.
if you could indicate,
at
but I
the,
can.
no, at the present
Please
stage.
indicate.
Yes, I indicate. Lordship will kindly come to 36-1, Lordship once.
Yes.
My point is a 36-2 application, Lordship, before Lordship will see the first, where the time for making an application to set aside the arbitral award under section 34 has expired. Lordship will pause here for a moment. The saving clause is then subject to provision subsection 2. Lordship will ignore that for the time being. That then subject to the provision subsection 2 is the saving clause. Such award shall be enforced in accordance with the provisions of CPC. Now, my right to enforce the award is after 120 days, 3 months, 30 days, 120 days. My right to enforce the award starts. I have filed my execution. During the 120 days, he comes up and files a judgment comes up and files a section 34. No problem. After the amendment was introduced 36-2, the point which I am canvassing is, Lordship, the 36-2 has also to be filed within that 120 days. Otherwise, my right to execution gets delayed. There is no provision. I'll just indicate, Lordship may be with me, I'll just indicate, there is no provision in the Arbitration Act for stay of the execution. It's only under the CPC. So 36, as soon as I file my execution, their right to stall my execution could only have arisen if it would have been filed within that 120 days. Now, Lordship will imagine a situation. Today, within
Supreme Court on that.
No, not Supreme Court on this. I'll just indicate the provision.
Your argument.
This was argued before the Delhi High Court as well as Supreme Court, but the judgments have not come up.
Wait for those judgments.
It all starts
better and much brighter.
It all starts when I get the decree. Now, Lordship will kindly appreciate one thing. I
don't have that acumen to appreciate this argument.
After award is passed and after 120 days, it's a decree. It's no more a deemed decree, it's a decree after the amendment. Now, after a decree is put into execution and there being no stay.
You know, Mr. Sinha, what
Yes,
to
yes.
I'll meet. No dip, no dip.
Tomorrow.
No dip.
Now
Tomorrow we'll appreciate this argument. You know, let it see.
I'm prepared to argue, Lordship, with unilateral. What was the object of
We will hear you.
Yes.
We will hear you. We'll see all the provisions. We'll hear you.
Yes. It's only the
no authority right now. Huh? Till now, there's no authority as such.
No, there is no authority as such. I did look into it. This was argued.
Argued, then what happened?
But no judgments have come up. It's all
observed.
No, it's all. I inquired from the advocates who had appeared in the matter also in Delhi. But see, it was argued, but no judgments have come up. It's still pending, and many matters it has been argued for the High Court as well as till the Supreme.
We should also hear it and.
My reference argument, Lord, is that if I do not file a section 36 within 120 days, then he has right to not execute, take away the money, irrespective not of.
No, it's not about taking away the money. It's about the right of.
That's exactly. Then the whole execution proceedings actually is a nullity.
My right to, Lordship, Order 21, there is a provision for stay. Now, Order 41 will come in.
Then the entire your execution proceedings.
Yes.
Anybody can take away the money completely.
No
question of 36-2 then.
If it is filed within 120 days, my execution get automatically stayed by virtue of this.
You are saying that everything is crystallized to 120 days, whether it is 34 or 36.
Yes.
Beyond that, nothing can happen. Only your execution can
Justice
lie.
Nariman also indicated in one judgment that 37 also 120 days. After that, he clarified that within a certain limitations, or Justice and in one of the judgments clarified that 37 also 120 days.
But he fortunately clarified because Mr. Kaha misses him a lot. I know.
Yes, we miss him a lot.
Misses his Lordship a lot more. I know that.
Tomorrow, not today.
I took help from some of the advocates in Delhi who are arguing this for the Supreme Court also.
You should shift your practice to Delhi.
In fact, my lord, though his name is Priyankar, my lord, most of us not call him Bhayankar. Because of his novelty not in his argument. My lord.
Lordship, section 37 application from an award from a section.
Item 19, I'm praying for short passover. Once Miss Sonioja is appearing, she is in another court.
If it's a old matter, if an award has already been passed, I am out. So if
Is the award passed?
My lord, I have to take instruction.
Take instruction.
Sonioja
Because
is
it's an
appearing.
old matter.
It's an old
I think
matter
probably
because
the award has been
I
passed.
also
If the
think-
award has been passed, it's merged. Nothing lies in 37. 37.
Lordship will indicate that if an award has been, let them indicate. I'll
I'll come up with the instruction.
Yes,
Come up with the instruction tomorrow, not today.
and let them come with the copy of the award also if it has been passed.
So that he can file a 34. That has to be supplied to you.
We have not received. Otherwise, 34
Then you
would have
ask
been
me
filed.
to record it that it has been supplied in the court, and then your
No, not required also because I have not
1920
received. They will have to show service also of the award.
Madam, come up with the instruction. If the award is passed, old matter, probably the award has been passed, 37 gets not maintained. Yes.
20. Same point, but probably different.
Same. Yes.
I
Award
appear-
passed?
Award passed.
Not.
No passed. Not passed.
Here, a section 16, section 17 order has been passed ex parte.
Yes.
I'll be candid, Lordship. There is a point which is
Chennai.
yes.
Yes.
After seeing it, I saw that it's Chennai, but ex parte award pass. I could have taken many points of law, but I find
Where do you get it that the arbitration matter? It's like the arbitration clause is at Kolkata. What I do have the instructions.
then if the point is not raised, I am.
You're not.
I have the agreement copy with me. The arbitration clause is at Kolkata. It's like I'm helping my other
No,
side.
very
right
well,
now.
very well. Let me continue then. I have no difficulty. Lordship, it's
It's the section 17 order is passed in Chennai. That is an admitted fact. That is an admitted fact. Section 17 order has been passed in Chennai.
if it's admitted, then that arbitration clause in Kolkata, it's when is in Kolkata, let us fight here.
Section.
If they want to start, if they want to fight, I am ready.
Oh,
with
if there
it.
is a question, no question of jurisdiction, I can proceed.
Yes, they can proceed. I have
But
my arguments ready.
The arbitration proceedings are being conducted in Chennai.
By the institutional arbitration lordship. The agreement has that clause.
So if that is there, then it should go before the Chennai High Court.
Lordship, but the seat of the arbitration is at the
Why
that
the
is-
point is raised, I will be candid, Lordship. If my petition goes, their section 9 at all material time goes from here.
That is the reason.
That is the reason.
not really.
That is
not
the reason. I could understand. Because it's all cyclostyle agreements, only filling up the. It's the point of jurisdiction, if it is raised here, for all lock, stock, barrel, everything will go from here.
Lordship, the agreement contains an arbitration clause where it is stated that the arbitration will be referred to the institutional arbitration process when it will be
So the institutional arbitration is being conducted at Chennai.
we have referred to the institution and they have appointed the arbitration. We do not have arbitrator. We do not have any hands in that process, Lordship.
So even this institutional arbitration thing, you have not challenged it.
We did not have any notice, nothing.
They had it. I have
That's the-
I have the service. I have the track report.
There are number of judgments. If the waiver of this point is waived off, then the number of judgments which I will rely upon, saying
And why the
unilateral
arbitration
appointment.
pending for such a long time in the institutional arbitration?
Lordship,
Why award has not been passed?
Lordship, the fact is the very moment they file, this is my verbal instruction, the very moment they have challenged the section 17 order, they have kept the arbitration process in abeyance. It's like because it has been challenged before this court, like there is no other reason there has not been, the award has not yet been passed.
How the arbitral proceeding should be conducted?
Lordship, I understand, but that is my verbal instruction that no award has yet been passed in this matter.
Lordship, may I do one thing? May I take a copy of the agreement which my learned friend is carrying and come back tomorrow and I'll place those judgments where unilateral appointment passed by this court, went up to the division bench, went to the Supreme Court.
That railway electrification that
no, in these kind of matters where hire purchase matters also, unilateral appointments have been done. All have been till the execution stage also. The awards have been said to be non-honest. A bunch of judgments passed by this honorable court went up till.
But then the arbitration proceeding has been conducted in
Maybe.
pursuance of the agreement, Lordship. It was the, it was there. May I hand it over to your Lordship the agreement? The arbitration clause is at page 4, internal page 4, Lordship, clause 13.
cyclo style.
Yes.
If your Lordship kindly comes.
If your Lordship takes this
13B of annexure 1.
Yes,
Annexure
Lordship.
1 is
It
this
says
one. 13B would be
Kolkata, Lordship. It is there. It is there in the agreement, page 12. Place of arbitration as well as the jurisdiction.
I would not like to take point of view if it is not. It is.
No, this is not. This is Delhi. You have all the choices in the world. Mumbai, Delhi,
But then Kolkata
Chennai,
has been chosen
Calcutta.
by consent of both the parties.
Where's the consent?
Lordship, they have signed it. There is a signature.
So all this should be set aside.
This is one of the judgments, Lordship. I will.
Contention what my learned senior friend is taking, that they have not received any copy of the invocation of the arbitration process or appointment of the arbitrator. Those are vague. Because I have the delivery report that has been duly served upon the
Come with all the judgment. All
All judgments are one of the in execution proceedings. It was. Yeah.
These are nothing.
In respect of the unilateral appointment, Lordship, I'll rest it to your Lordship.
It is one of them, but it has lots, loads of those judgments are there. I should have got it.
It is clear as a summer day.
In fact, your Lordship has also passed an order recently in respect of this institutional arbitration.
Yes, that Mahua
Bhumik versus Ugro Capital, Lordship, yes. Oh, institutional arbitration is also a unilateral appointment. In effect.
both of you come.
I myself, I would be very candid before your Lordship.
Take instruction.
I myself
We get
has already spoken to my client, Lordship. I know your Lordship's.
We'll get a arbitrator appointed.
My client is okay with that. I mean, they have given me instructions. I myself have spoken to them. I have a written instruction as well, because I myself have told them that this is an unilateral appointment in view of that Mahua Bhumik order, Lordship. So there might be that the this order might get set aside, and your Lordship may direct us to take us instructions. So they are like, if it is fallen from your Lordship that we go by appointing an arbitrator by consent of the party, so we are okay with it.
We can
anybody Lordship can appoint. I have no difficulty.
The petitioner has preferred the present petition under section 37 of the Arbitration and Conciliation Act, challenging the order dated 25/8/2025. First up, it is the contention of the petitioner that the arbitrator was appointed unilaterally without the consent of the petitioner. Full stop. Petitioner further states that such unilateral appointment is against the settled principle of law. Full stop. Learned counsel for the petitioner relies on the judgment of the Honorable Supreme Court, such and such, wherein the court has held that unilateral appointment of the arbitrator leads to had held that the unilateral appointment of the arbitrator is illegal, and it clouds a doubt on the very arbitration proceedings. Full stop. Keeping in Full stop. At this stage, learned counsel for the respondent states that she is agreeable to a fresh appointment of the arbitrator to adjudicate the dispute between the parties. Full stop. She states that she had received instructions from her client to get a new arbitrator appointed. Full stop. In view of such facts, and without entering into the merit of the matter, the order dated 25/8/2025 is set aside. Full stop. With the consent of the parties, Mr. Give a name. Give any name of anyone.
Asif Hussain.
He is here only, my lord.
Asif Hussain. Mr. Asif Hussain is appointed. You want to do it?
But not very difficult. Yes,
Yes, he's very. I can't use that word, but somebody did just recently. Mr. Asif Hussain is appointed as an arbitrator to adjudicate the dispute between the parties. Full stop. The arbitrator is at liberty to decide his fees in terms of Schedule 4 of the Arbitration and Conciliation Act. Full stop. The copy of this order shall be communicated to the learned sole arbitrator. Full stop. With the aforesaid direction, the present petition stands disposed of. Appeal stands disposed of. Along with the connected application. Appeal stands disposed of along with the connected application. Oh, I'll give you electrification. Hey, Gopal was Supreme Court वाला judgment है ना, electrification, that rural electrification. Vote. Detail. You give it to me. I'll. You can take the copy. Next.
If you want similar, respondent is different than 17.
I'm appearing on behalf of the respondents, Your Lordship. My senior is not available for this week. I'm praying for not this week.
Get me instruction whether the award has been passed.
It's an old.
No, I don't have an instruction.
That's what I'm saying. I'm not saying you have the instruction. I'm saying get the instruction on the next date whether the award has been passed or not. Who's your senior?
Anna Malhotra, Advocate Anna Malhotra.
Learned counsel for the respondent seeks and is granted. Learned proxy counsel for the respondent states that the main arguing counsel is in some personal difficulty. She prays for an adjournment. Let this matter be adjourned to 23rd February.
Highly.
Now 14, and now 22.
Again, nobody's here. 14 is you have to
14 is my contempt, my
serve
lord.
them.
Yes. And my lord, insofar as my lord,
Serve
20.
them so that they're not here.
Very well.
It's better to serve them.
They have served.
Item 14, learned counsel for the petitioner seeks and is granted 2 weeks time to effect service upon the respondent.
My lord, would your lordship allow me to, my lord, serve, my lord, the advocates who are appearing in the arbitration? Because
At least first attempts, try to serve them.
that very
If they are not served, then we'll see that. 2 weeks time to serve on the respondents. Let this matter be listed on 24th February. 24th. We are 14 now. And 22 is that is also your appeal, right?
No, my lord, it's their appeal against the order of which I'm alleging willful disobedience.
You're there?
I'm the applicant.
So he's here.
Right.
Who do you appear for? All the respondents? Take your breath.
Lordship, in this matter, my lord, learned advocate. Sorry, my lord.
Take your breath. I'll come back after 5 minutes.
Wait.
Lord, I am the appellant, my lord. In this matter, my lord, landed advocate, uh, uh, Mr. Chaudhary, Jisnu Chaudhary is appearing today. My lord, kindly fix the matter tomorrow, my lord, so that I can.
You appear for all the respondents?
Lordship.
They have filed an application too. Have you received a copy?
No, my lord.
Item 14.
No,
I'll hand it over to my friend, my lord, in the course of the day if they haven't received.
Give a copy.
We will.
Your application is, what is the application?
My lord, it's a contempt. They have been asked to do, my lord, certain things, they are not doing it. May I briefly, my lord, just indicate, my lord, what the matter is? The advocates have been served, I'm told. My lord, this is, my lord, a tripartite. My lord, for a moment, my lord, before I place the order, my lord, for a moment, my lord, I'll just summarize what the case is. It's a tripartite, my lord, agreement. Petitioner number 1 is one party. Petitioners number 2 to 4 are partners of a partnership firm, essentially, being the other party. And, my lord, the respondents are the third party. Respondent number 1 being the firm and the other respondents being the partners of that firm. So essentially one private company, that's petitioner 1, one partnership firm, that's petitioners 2 to 4, and another partnership firm, that is the respondents. Now, my lord, a JV agreement was entered into for these three entities to undertake projects, infrastructure projects. But, my lord, before this JV was entered into, these entities had already started working on a project together at the Calcutta Port Trust. Now, this project, my lord, under the Calcutta Port Trust, which was being given to three entities, was prior to the JV being conceived. So, my lord, they entered into two agreements on the same day. One is the JV agreement, which says that they will take steps and constitute a separate entity where shareholding will be 33 one party, 33 one party, and 34 one party. And along with that, they got into a supplementary agreement. And the terms of the JV were incorporated in the supplementary agreement, and the invocation of arbitration is under both JV read with the contemporaneously signed supplementary agreement. In the supplementary agreement, it is mentioned that one project is already undergoing, which these parties are doing together. Since the JV has not been constituted and that will take some time, so by way of a supplementary agreement, an interim arrangement was made. In that interim arrangement, it was mentioned that the project which is being undertaken will be taken from the port, the concerned company, in the name of the respondents. Because one person had to be the contracting party, and that it was recorded in the supplementary agreement that the petitioner 1 and the petitioners 2 to 4 are also making contributions. They have started working on the project in support of the respondents, and as part of the profit sharing arrangement, interim arrangement, the respondents would share all the bills which are being raised by the respondents upon the party whom the respondent was servicing, and the money coming in these accounts. And, my lord, we will get 10%. Both these parties, the petitioner 1 and the petitioners 2 to 4, will get a certain percentage of those bills, my lord, as their remuneration. This is, my lord, the long and short scheme. Now, my lord, we invoked arbitration because we've learned that they've received 5 crores for the work that all these parties have done together, but the money has gone to them, and they are, my lord, contractually duty bound to make these disclosures to us so that we could assess what our profits are. So, my lord, this has not been done. So, my lord, arbitration was invoked. In the after invocation, we filed a section 17 application. We only prayed, my lord, for this information to be disclosed, that you please furnish particulars, at least to the tribunal, of what is the business that you've done with this particular entity on our project, because it's our project. So, my lord, in that section 17, an order has been passed, my lord, directing them to furnish particulars. They have not done so, and instead, my lord, they have come, my lord, by way of an appeal challenging that order, and their only, my lord, ground is one, that this amounts to fishing of evidence, which should not be allowed. To which, my lord, I have one answer, that if I am accusing you of doing a wrong, and I'm compelling you to give evidence for me to prove you're wrong, that would perhaps be unconstitutional. One can't be, my lord, compelled to give evidence against himself for his own, my lord, prosecution. But here it is not so. I'm not seeking, my lord, any particulars for any wrong that they have done, because it's my own case that they were to take the project in their name, because one of us had to volunteer, and it's a contractual right that I have to get these disclosures, and the agreements, my lord, execution of these agreements are, my lord, not denied. And my lord, it's innocuous. If at all, my lord, they are concealing this, my lord, it shows, my lord, their, my lord, malice. Otherwise, my lord, if a partner, my lord, cannot seek disclosures, my lord, then, my lord, the entire scheme of partnership, my lord, is jettisoned.
So you're filing a contempt against the order which has been passed under section 17.
17, where they have been directed to make disclosures of, my lord, bills which they have raised upon this particular entity for whom we were all working at the port, and the money that has come into their account. And, my lord, they are not making those disclosures. This is, my lord, the long and short of the matter.
And they have filed this challenging the very passing of the order.
Very passing of the order, my lord, under section 37. And the ground that they've taken is that this amounts to fishing of evidence. I mean, I have clarified how this is not fishing of evidence, because I am not wanting, my lord, to them to give evidence.
But they're not raising the ground of maintainability of this arbitration proceeding under 17 and all.
No, my lord, that for that they'll have to file a 16, which I don't think they have. If they want to challenge, my lord, the tribunal's jurisdiction, and, my lord, at the section 11 stage also, my lord, they gave consent for the arbitrator to be appointed. And these agreements, my lord, which have been executed have not been...
To be appointed only to the extent of the JV, that tripartite agreement. Which
JV read with the supplementary agreement.
Affidavit, they are agreeing to that.
Yes, my lord. JV read with the supplementary agreement, and both executed on the same day, both contemporaneous documents. They essentially comprise one contract where there is an agreement, and along with that, there is an interim arrangement until, my lord, certain steps pursuant to the agreement are taken. Because, my lord, overnight, my lord, a new entity cannot be formed. My lord, compliances are to be done.
You appear for whom?
Lordship, I am for the all appellant.
All the appellants. Both the companies.
Lordship.
So we'll keep it tomorrow then in that case. Tomorrow?
Lordship.
Tomorrow, my lord, I'll just place the relevant portion of the order and the contempt, my lord, which they are.
Lordship, it is not right, my lord, say something, because learned advocate has been appointed to argue the matter. Main party has not been included in the arbitral proceedings. The bill which has been raised, that party, main party, is not the party to the proceedings. In the
how will they be?
Lord, I will come back, my lord, with my senior, my lord.
Bill would have been raised to a person for whom you have entered into the contract and done the work for. How can they be a party to the proceedings?
Exactly. That is it.
That would be a third person whom you have rendered the services. The services, for rendering of the services, you have entered into
A Singapore company which was doing something for the Calcutta Port Trust, that Singapore company engaged us as their subcontractor. So we amongst ourselves decided that you will be the contracting subcontractor, and we'll assist you and get a share in the profits. Because the JV could not have been, because the JV was yet to be, my lord, formed. The incorporation of the JV was pending.
This APCOM 892 is the petition filed by them, right?
What is the number? Was this that?
892 is your 14.
14, yes, my lord. 892 is, my lord, the contempt. VKM projects, yes.
They have taken time to file their reply and all. If you see the order of 1st of December in 892, Respondent file affidavit.
They cannot sign.
Not been served. Till today, not been served.
How are they
No,
taking
but
time?
this was taken up on 1st of December.
Has it
See
appeared?
the order, Mr. Lucky.
I moved it, but they did not appear.
Yes.
Order should-
They did not appear.
Wait.
Next order, next.
This is the first time when they appeared. There was a direction on them to file the application. Seem to my serving the application. Without serving.
Yes, my lord, they did not appear that day, my lord. My lord, my friend was there. I'm told, my lord, that they did not appear that day.
There's a recording. They'll file their affidavit.
Yes, your lordship directed so, my lord, but none, my lord, is shown to have, my lord, represented, my lord, the respondents.
You kindly direct them to serve the copy, my lord. Without having copy, my lord.
Give a copy.
Can you give it today?
Yes, I'll
Today,
do it.
please.
Yes.
In course of the day, my lord, I'll hand it over to my friend. Now that he's
Item 14, record that. Learned counsel for the respondent is dispatched. 6 and is granted. Further time of 3 weeks to file their affidavit in opposition. Reply to the same, if any, within 1 week thereafter. List after 6 weeks.
3 weeks. Oh.
Well, and 22 we'll keep it. You want it tomorrow?
Tomorrow.
Not today.
22, I believe, my lord, if your lordship just gives me that rider, that whatever they've stated is not considered to be true and correct by me.
No, my
I
lord,
can
kindly come back tomorrow.
I can argue it. I
Kindly
can
come
argue it without, my lord, really putting it up, because, my lord, this is really an impediment now, my lord, to the arbitration proceeding further. Because how do I ascertain my claim?
We'll see it tomorrow.
Very good.
Let Mr. Chaudhary come.
He'll have something up his sleeve for sure.
I'm sure.
কালকে হবে।
22, not today.
Grateful.
God bless.
Not 23.
My lord, I'm for the petitioner, my lord, praying for not today, my lord. Planet senior is not
Not
available.
today.
My lord, I am for the respondent claimant, my lord, in this matter, my lord.
In my application under section 34, my lord, there is some delay before, my lord, beyond
My lord, may I
90
indicate, my lord,
days.
there is a soft copy has been served directly to my client, my lord. The petition, my lord, contains 7 volume, my lord. That was transferred to me, but my lord, I have not been able to download it. My lord, my advocate on record, my lord, has filed wakalatnama yesterday. She will write a letter, my lord, kindly direct them to serve a copy to it. And my lord, I will take a objection, my lord, preliminary objection, my lord, as regards to the limitation point, my lord. I want to raise.
Is it beyond 120 days?
No.
According to me, it's beyond 120 days.
Maybe
According to me, it's beyond-
129th or 119th or 120th day.
They are
Not within.
saying 2 days
I have
before.
checked, it is on the 16th. I have checked the High Court website. It says on 16th.
Yes, they are
And that
saying
is the date of expiry.
They are saying 1 or 2 days before. According to me, it's beyond.
Very well. Let them check up and come
Let
back.
the petition serve to us, my lord. I will.
If it is beyond, my lord, yeah, even I cannot.
When do you want?
Next week?
My lord, next week, my lord. And then in the meantime, my lord, I will write a letter to them, my lord. They will serve me a copy.
The petition has.
I'm led by Mr. Kishore Dutt.
Who? Mr.
Dutt? Senior Counsel, Mr. Kishore Dutt. Kumar Dutt.
Would I simply make it not today, or I'll Give directions. What do you want?
My lord, may record online order, my lord, to serve copy of it. We have not been served.
Learned counsel for the respondent states that he has not been served with a copy of the petition. Full stop. Learned counsel for the petitioner shall serve upon the respondents. Respondent. Only one
Yes,
respondent.
I am for the respondent claimant. Claimant in the arbitration is respondent.
List on 20 days. 3 months. What is the? And 3 months. 3 months. Not March. 10th February.
30 দিন শেষ হচ্ছে 17ই জানুয়ারি, আমরা 16 তারিখ পাই।
It will appear on Monday, my lord.
10th is what? Tuesday.
Tuesday.
Great.
Look, 10th I may have some difficulty in this. Can it be 11th or 12th any day? Subject to your lordship's.
No urgency as such, right?
No urgency.
24th.
24th February. Grateful. Grateful.
What happened?
That's fine.
25. 25.
Yes.
I was in claim number 1. We were discussing on claim number 1.
You'll do now or after lunch? Up to you.
Can I come after lunch also?
After lunch? We'll take it up.
Kindly allow me to join virtually, my lord. I'm in some difficulty.
Where are you, Mr. Saha?
Lord, I'm in the NCLT, my lord. I'll come back, but
You'll be there after lunch also?
no, my lord, I will come back, but my lord, I have an arbitration fixed in Bombay, my lord, which I'll be joining virtually. So, my lord, I will be, my lord, hearing Mr. Sen's arguments, my lord, if your lordship permits me.
Then we'll start afresh and after lunch.
Grateful, my lord.
You are there in
Next matter in the monthly list. Mr. Shah, I'm being led by Mr. Shah.
he will take. How much time are you going to take?
I will take.
This will take some time.
Take some time.
All right.
If your lordship permits me, I can come tomorrow.
Let's start this one. Let's start because we have already
one claim only. I have rejoined.
Right. So let us.
Well.
Unless fully ready, I can't. Will not be able to assist you very well. I will.
No, if you're not fully ready, I mean, I'll accommodate you, but
yes, I'll start. I'll finish. Yes. I'm not like Lord yesterday. He confidently argue what is not there.
Okay.
We'll come back at 2 o'clock in that case.
After
2. We were, my lord, on the claim number 1. I had given your lordship the background of the claim and what was my defense to the claim. Actually, one of the claim, if your lordship sees, was additional overhead cost due to prolongation.
Yes.
It is like this, they say, style it as this: unrecovered additional establishment cost due to extension of phase 1 part of the work. Now, the statement of claim pleading, the grounds on which they are asking for this unrecovered additional establishment cost and why this delay happened, they have categorized into various categories, which includes A, delay in handing over of site and some other predicaments on the part of the employer. Apart from this delay, they have also categorized delay on various other categories, namely diversion of utilities, and also, my lord, that fact that there was change in the alignment. So, my lord, we had threefold defense here. First defense is on the ground of clause 8.3, that there is a no damage clause. If you are asking for extension of time on the ground of delay in handing over of site, you are unconditionally entitled to extension of time as a matter of right, but this will not give you a right to claim damages. So it was contemporaneously, there was an agreement, you sought for extension, I gave you extension on the same terms and conditions, incorporating 8.3. You accepted the extension. Now you cannot, at this stage of challenge to the award, or you cannot make a claim saying that even if there is 8.3, I am entitled to damages in the nature of unrecovered additional establishment cost. With regard to the other ground, they themselves are saying that because of these factors, employer's variation has been granted. There is a clause in the contract for employer's variation which says that if there is any change in the employer's requirement, then they will make a request for employer's variation. Based on their request, employer's variation will be granted. So when those changes were notified to them, they applied for employer's variation. They have obviously taken into consideration the additional establishment cost. And because based on your proposal, what should be the employer's variation? You have quoted, I have given it to you. There is an unconditional acceptance of that. Documents are on record. There also, you have asked for establishment cost as part of the employer's variation. Not only that, as part of the second claim, your main prayer is, while granting employer's variation, establishment cost has been awarded or given to them at 15%, it should be 20%. This claim has been allowed, and now you have got the amount of additional establishment cost on account of employer's variation at 20% under this award itself. Third defense was that the realignment which took place, which is also your ground for recovery of additional establishment cost, due to this realignment, you have accepted the realignment proposal. When you gave the proposal, there also this part has been taken into consideration. So there are three parts of my defense to this, my lord. I will just hurriedly show your lordship, my lord, these aspects of the defense insofar as the claim is concerned. Kindly first, my lord, let me show your lordship the clause relating to employer's variation. Yes, 23.1. If it is already marked, that means I have shown it, but I'll let 23.1 of the, this your lordship will get in volume 2. I think volume 2 was
volume
184. 23.1.
You have shown it.
Yes. And kindly turns the next page. E, 185, clause E.
In 23.1, you had shown A, Roman 3.
Yes, and E, and the next page, clause E. In case of any variation, once rates have been finalized by the engineer and approved by the employer, contractor shall be bound to it. No claim shall be entertained by the employer in this regard. So this is what we have relied upon. Now kindly see three documents, my lord, which we have, which is part of this defense. This is relating to the revised alignment. In volume 4 technically. If it is already marked, that means I have shown. I do not. Yeah, kindly turns to page 563. Yeah, 563 is, kindly see, subject revised alignment of Kolkata East West Metro. The date is 25th of August 2015. Here we are communicating that revised alignment of Kolkata East West Metro in phase 2 has been approved. Alignment will go to Esplanade Station after Shalda instead of Central, which was shown in the alignment plan. Now kindly see last paragraph. You are hereby mentioned, being hereby that contemplated present scope of UG2 contract will end at west end of Esplanade Station. You are being advised to take action accordingly to initiate your scope of work beyond Shalda under UG2 contract along revise. So I am inviting him. What will be your change? You indicate. Now kindly see thereafter 8th November.
Page 570.
Yes. Yes. 570, page 570. This is the last limb of the defense. Employer's variation due to revised alignment. 570 is dated 8th November 2016. Has your lordship got it?
Yes.
Kindly see the subject. Employer's variation for revised alignment. ITD's techno-commercial offer. Kindly see first paragraph. Employer's variation submitted by you, dated 6th May 2016, amounting to rupees such and such, has been accepted by appropriate authority. So based on your revised drawing, you have given your techno-commercial offer, which we have accepted. This is to inform you, design part of employer's variation has already been issued to you, amounting to such and such. For item number, which start date will consider date of issue. Presently, the balance part of the said employer's variation for realignment is being issued and comprehensive BOQ is enclosed. Revised enhanced contract value against UG2 contract is such and such, exclusive of all others. Original contract value was 908. Against that, revised contract value is 1279. Kindly turns the next page. Last three paragraphs. The terms and conditions for this employer's variation communicated by your techno-commercial offer, duly reviewed by KMRCL and accepted by you by letter under reference 7, will form a part of this employer's variation and is enclosed. You are hereby take necessary action towards mobilization and accordingly complete the work. Requested, kindly see the last line. Requested to submit unconditional acceptance of this variation order. Kindly see thereafter 572 to 574. 574, your lordship will get the amount 621, which is the employer's variation amount for the revised alignment. Acceptance to put at which 574, your lordship will see it has been signed by the agency. Signature of agency approved. So this is the final acceptance of the employer's variation. So it is not that the employer is dictating, this is what the amount is. First techno-commercial offer has been submitted by you based on the revised alignment. So, my lord, in this context, my lord, we will now have to look at the reasons given. Because as far as I remember, primarily when argument is being made that whatever is written it does not reflect proper reasons. That was the nature of the argument. Now, because these are therefore essential facts which have been taken into consideration. Kindly come to the finding part of the claim number 1. Now,
page.
I like this page. This is page 60. 80s discussion ওখান থেকে আরম্ভ হচ্ছে তো 59 last paragraph. Kindly turn to 60 Roman 1. Both the parties have agreed there have been delay in completion of the assigned task by the claimant on account of delay in handing over of worksite, traffic restrictions imposed by Kolkata Traffic Police, and assignment of additional work due to employer's variation. Their case, respondent has aptly submitted that both parties followed due process of the contract contained in clauses 12.3, 12.4, 3.5 of GCC in deciding the variation process with necessary adjustment to contract price and time for completion. This is the clause relating to employer's variation. 23.1 ought to have been mentioned here because 12.3 read with 23.1. The cost of variation work and the consequent time for execution was determined by engineer GC, which obviously would have taken into consideration additional establishment cost of the claimant upon the extended time granted for execution of additional work. Lot of emphasis was given on this word obviously by Mr. Saha, as if it is based on surmise and conjecture. If your lordship reads this line with the entire mechanism in the contract for granting employer's variation, then, my lord, this conclusion will obviously follow. Because you are asking for cost as additional establishment cost because the employer's variation has been granted to you. How then, what becomes important is how is an employer's variation worked out? That is the mechanism in clause 23. You apply based on the variation of the employer's requirements and say this is the cost which is involved. That is analyzed by the engineer, forwarded to the employer. Employer grants it, gives it to you. You have not raised any objection as regards the employer's variation. Then 23.1 will come, 1E will apply. That is why, my lord, the word obviously has been given. Because you have also, because it is in your statement of claim that this delay is on account of employer's variation, not on any other thing. Now, the next line is also important. The establishment was utilized for variation works during low activity in the main project. Both the parties have agreed that unqualified extension of times were granted by the respondent after due process of review of the application submitted by the claimant, obviously agreeing with the responsibility for delays by the respondent employer with due consideration to relevant contract conditions, specifically 2.2 and 8.3. So, my lord, on the ground of delay in handing over of work site, reference has been made to clause 2.2 and 8.3 of the GCC. The respondent has submitted that the claimant secured 695 crore work on single tender basis and an updated price in December 2015 to complete the UG2 contract on a diverted alignment, which would have helped the claimant in better utilizing their establishment cost. So this is my submission based on even for the new alignment work, there has been an employer's variation. Huh? But for this, I may refer to my statement of defense. I'll show one paragraph there. If your lordship takes that volume 4, which was given to your lordship, para 21. No?
Para 20, page 513.
513. Kindly see 513. Just 512 last line, para 21. With reference to allegations on para 29, it is stated UG2 contract was awarded for complete work from Subhash Sarovar to Central State for contract value of 908. Establishment cost of the claimant was not for the stretch from Subhash Sarovar to Shialda as mentioned by the claimant, but for the entire stretch up to Central. There was a proposal by Government of West Bengal for change of alignment. In the year 2012, alignment was effected from West End to Central Station. Realignment was approved in August 2015. Claimant was advised to complete contract by following alignment from Shialda to Esplanade. This is the letter which I have placed before your lordship just now, 25th of August 2015. Then, my lord, further techno-commercial offer was required for this realignment variation to complete the contract, and the same was intimated to the claimant. The respondent mentions that the claimant had the option to serve notice for termination as per clause 13.1 read with clause 20 SCC due to this access issue from Shialda to Central. Instead of this move, the claimant had submitted techno-commercial offer for positive variation of 695 along the realigned route, which includes claimant's establishment cost also. Wide letter dated 28 December 2015. So you have given an offer for 695 crores. A copy of the letter is annexed here to and marked at the end. Thus, entire change aspect of the contract covering changes in project execution time span as well as have already been covered by the claimant in the techno-commercial offer submitted. There is no merit for claim. On the date of finalization of realignment variation on 8th November, amount of work of value of contract scope left in the portion from Subhash Sarovar to Shialda was 62.94, which was only 9.05% of the work quoted for realigned portion. Thus, it is imperative majority of the claimant's establishment cost in the extended period has been involved in the execution of this substantial additional work in realigned portion, which has been covered in the techno-commercial offer, as it contained both additional time and additional cost and several other conditions over and above the original contract agreement. And then we approve that, and that is page 570 and 574, which has been unconditionally accepted. So, my lord, if I now, so in this perspective, your lordship will examine subpara 4 of the finding at page 11. That page 60. Thereafter, kindly see further subpara 5. In view of the above, nil amount is awarded against this claim, especially in view of the following. So I would say, my lord, he has given his initial reasons and further, my lord, qualified the reasons. Here, EOT on account of has been granted on account of delay on clause 8.3, and the GCC clauses 2.2, 8.3 has very clear and explicit provision against any damages and compensation. I will come to those clauses also, my lord. But here, my lord, a arbitrator has referred to a contractual clause, interpreted the contractual clause. there is, my lord, with the greatest of respect, my lord, there is no scope for reopening it. But at least, my lord, this submission is not made that this is a conclusion regarding 8.3 and 2.2 which no reasonable person could have come to. That is not their case. Rather, they are making a different case. They are trying to go back behind the clause. They are trying to raise an argument here that clause could not have been given effect to. Without a specific challenge to a contractual clause, it is not possible for the arbitrator to go around that clause and say that the clause cannot be enforced. Clause is there on the face of it. You have not challenged the clause during the contract stage, even at the post-contract stage. I have placed from the statement of claim. This argument was never made that it is void, cannot be enforced. Next, my lord, kindly see subpara 6. Notwithstanding with the claim being inadmissible, method of calculation of claim amount by the claimant is unacceptable in view of the following. Average amount of establishment cost of manpower, machinery, equipment, etc. of 266.29 lakh per month have been worked out for a period of 95 months, and the same have been extended for the entire period of extension, having the period of low as well as optimum activities, which is considered disproportionately high for completion of the entire work of just 657.95 crores. From the response of questions by the claimant and remarks of the respondent, it is noted that level of resources for the baseline program was not specified, and the claimant had free hand in deployment as well as demobilization of resources with permission from the respondent, which was at no time denied in view of availability of work fronts. There has been no submission on verification of deployment of men and machinery. But here the arbitrator cannot be faulted, because they have chosen not to go in for oral evidence. That is a difficult stand to take in case my claim is entirely on damages. In whatever form, I have to lead evidence at least for the purpose of proving the quantum of my claim. And it is not the case that this is a form of damages which is based on admitted documents. So again, my lord, they cannot say that this part is Dehor's evidence based on no evidence or contrary to evidence on record. First of all, it is a case of reappreciation is not possible. They only have to stick to the stand that this was uncontroverted evidence on record which ought to have been considered. Now, the arbitrator has said there has been no submission on verification of deployment of man and machinery. So therefore, in other words, to say that whatever document was given was not an uncontroverted, unassailable piece of evidence. This much it is there. Claimant's contention that claim number 1 is not arising out of idling of resources, but it is for unrecovered establishment cost is beyond comprehension and hence not acceptable. But it is, but these two things cannot be separated. Additional establishment cost will also include, in other way, resources which are there cannot be utilized. I am only phrasing it in a different way. Why I am seeking the additional establishment? My establishment is there. I have had to run the establishment, but could not utilize the establishment for the purpose for which it is there. So that is why, it is being said here that it is not entirely different. Two cannot be separated completely. It is a different way of phrasing it. Then, my lord, kindly see. Acceptance of such logic would guarantee additional payment to contractors devoid of any motivation for early completion of a project. Bidders do undertake site visit and risk analysis before bidding for such a mega metro project, duly considering wide prevalent delays in acquisition. All the bidders were aware of the existing contract provision, opportunity was available, factoring it in bid for delays. Yes, now he has also dealt with clause 8.3 also. The claimant's contention about contract becoming void on account of excessive delays in handing over of work sites cannot be accepted. In view of express provisions of 8.3, there would be state of stark incongruence if on one hand the contract is considered void on account of substantial delay in making work site, while on the other hand provisions of all other provisions are intact for proceeding with the completion of the project. The claimant has raised a pertinent point regarding inadequacy of the GCC clause, not specifying a limit to extension of time without, but the claimant's proposed solution is equally repugnant. So, my lord, if I summarize the reasons, my lord, firstly, he says delay on account of delay in handing over of work site, that is inadmissible, 8.3 and 2.2. As regards the, my lord, employer's variation, delay due to employer's variation, he says, well, that is, you have already got the employer's variation. Clauses 12 and 23.1 stands in your way. And finally, my lord, your lordship will see the last part, which is the delay due to the revised alignment. That also, my lord, they have accepted the variation unconditionally. So, my lord, these are the three grounds on which this claim has been gone into. So, my lord, if I first deal with the aspect of reason, whether all this, the findings recorded in paragraph page 60 and 61 can be classified to be devoid of any reason at all. And let us see, my lord, Dyna technology. I think my learned friend has also cited that. I'll also rely on that, my lord. এটা কত নম্বর এটা সাইটেশনটা 2019 না 20
2019 volume 20
China would be 2019
yes আমার কাছে নেই কেন
होगा होगा
ও আচ্ছা আচ্ছা I have
mark করো
আচ্ছা it is 2019 20 SCC আচ্ছা আমার কাছে আছে কপি আছে
you have to give me a copy
এই যে হ্যাঁ দিলাম তো দিয়ে দিয়েছি পেজ হচ্ছে 1 1 second. So the ground taken, my lord, the single judge had affirmed the award. Ground before the division bench, my lord, was that there was no sufficient reason. If your lordship sees paragraph 13 at page 8, aggrieved by the aforesaid decision of the learned single judge, respondent appeal before division bench, as aforementioned, the High Court by the impugned order partly allowed set aside the award relating to claim 2. High Court was of the opinion that the award does not contain sufficient reasons and the statements contained in para 3.1a to 3.1g of the award does not provide any reason, discussion or conclusion. Then the judge In this context, my lord, your lordship will kindly come to the relevant part. Paragraph 20.
24, 25.
Yes.
33, take a 34.
24, 25, my lord. 24 is at page 12. There is no dispute that section 34 of the Arbitration Act limits a challenge to an award only on the grounds provided therein or as interpreted by various courts. We need to be cognizant of the fact that arbitral award should not be interfered with in a casual and cavalier manner unless the court comes to a conclusion that the perversity of the award goes to the root of the matter without there being a possibility of alternative interpretation which may sustain the arbitral award. Section 34 is different in its approach and cannot be equated with a normal appellate jurisdiction. The mandate on 34 is to respect finality and the party autonomy to get the dispute adjudicated by alternative forums provided. If the courts were to interfere in the court's usual course on factual aspects, then the commercial wisdom opting for alternative dispute resolution would stand frustrated. Then, my lord, kindly come to 26, second line. The primary contention of the learned counsel appearing on behalf of the appellant is that the award by the tribunal was perverse for want of reason. Then, my lord, section 31 has been quoted. Ultimately, your lordship will kindly come to 29. No, not necessarily. I'll straight away go to 34. Russell has been quoted. Well, let us come to straight away the ratio. 34. Page 1434. The mandate on the 31.3 is to have reasoning which is intelligible and adequate, and which can in appropriate cases be even implied by the courts from a fair reading of the award and the documents referred to thereunder if the need be. So this is the test, whether reasons are there in the award or not. One, reason is intelligible and adequate. It can be implied by the courts from a fair reading of the award and documents referred to thereunder. The aforesaid provision does not require an elaborate judgment to be passed by the arbitrator having regard to speedy resolution of dispute. When we consider the requirement of a reasoned order, three characteristics of a reasoned order can be fathomed. They are proper, intelligible, and adequate. If the reasoning in the order are improper, they reveal a flaw in the decision-making process. If the challenge to an award is based on impropriety or perversity in the reasoning, then it can be challenged strictly on the grounds provided under section 34. If the challenge to an award is based on the ground that the same is unintelligible, the same would be equivalent of providing no reasons at all. So, my lord, I do not think, my lord, their case was this far that at least that it is absolutely unintelligible. Coming to the last aspect concerning the challenge on adequacy of reasons, the court, while exercising jurisdiction on the 34, has to adjudicate validity of such an award based on the degree of particularity of reasoning required, having regard to the nature of issues falling for consideration. The degree of particularity cannot be stated in a precise manner, as the same would depend on the complexity of the issue. Even if the court comes to a conclusion that there were gaps in the reasoning for the conclusion reached by the tribunal, the court needs to have regard to the documents submitted by the parties and contentions raised before the so that awards with inadequate reasons are not set aside in a casual and cavalier manner. On the other hand, ordinarily unintelligible awards are to be set aside, subject to party autonomy to do away with reasoned award. Therefore, the courts are required to be careful while distinguishing between inadequacy of reasons in an award and unintelligible awards. So, this is very much, the guidelines have been properly framed. Under what circumstances the court can go into the reasons. And that too, the Supreme Court says The court can imply the reasons, look into the document, look into the case of the parties. So only saying that the arbitrator has come to a conclusion based on an obvious, using the word obvious, makes the award perverse, my lord, with the greatest of respect, my lord, may not be justified, my lord. They have otherwise made detailed discussions on it. So, my lord, here, my lord, my submission will be, if your lordship applies the principles which have been laid down here, my lord, the reasons are not unintelligible. I would rather also say that it is not inadequate reasons also. My lord, he has analyzed, my lord, he has referred to the contractual clauses with regard to the first part. He has also referred to the clause relating to employer's variation. What else, my lord? Also on the aspect of quantification, he says, my lord, this was not adequately proved. The next, my lord, the judgment which I rely on is OPG power.
Go ahead.
কোন প্যারাগ্রাফটা দেখেছিলাম? 80 to 83. Straight away, my lord, kindly come to paragraph 80. Dyna has been approved, my lord, in paragraph 80. We find ourselves in agreement with the view taken in Dyna Technologies as extracted above. Therefore, in our view, for the purposes of addressing an application to set aside an arbitral award on the ground of improper or inadequate reasons or lack of reasons, awards can broadly be placed in three categories. Where no reasons are recorded or the reasons recorded are unintelligible, where reasons are improper, that is, they reveal a flaw in the decision-making process, and where reasons appear inadequate. But I say that none of the three conditions, my lord, are fulfilled here. Awards falling in category 1 are vulnerable, as they would be in conflict with the provisions of 31(3) of the 96 Act. Therefore, such awards are liable to be set aside under 34, unless the parties, this is not our case. Awards falling in category 2 are amenable to a challenge on the ground of impropriety or perversity, strictly on the grounds set out in 30. So this part they are not coming under. It's not a perversity or a flaw in the decision-making process. Awards falling in category 3 required to be dealt with care. In a challenge to such award, before taking a decision, the court must take into consideration the nature of the issues arising between the parties in the arbitral proceedings and the degree of reasoning required to address them. The court must thereafter carefully peruse the award and the documents referred to therein. If reasons are intelligible and adequate on a fair reading of the award, and in appropriate cases implicit in the documents referred to therein, award is not to be set aside for inadequacy of reasons. However, if gaps are such that they render the reasoning in support of the award unintelligible or lacking, then the power under 34 may be exercised and award may be set aside. So if I just pause here and say, my lord, so their case has to be that the gaps in the reasoning are such that the reasoning is rendered unintelligible. I do not think, my lord, they have even placed their case so high to make it fall within this limited scope. Next, my lord, paragraph 84 is also, my lord, important for us. An arbitral tribunal must decide in accordance with the terms of the contract. In a case where an arbitral tribunal passes an award against the terms of the contract, the award would be patently illegal. However, an arbitral tribunal has jurisdiction to interpret a contract having regard to the terms and conditions of the contract, conduct of the parties, including correspondence exchanged, circumstances of the case, and pleadings of the parties. If conclusion of the arbitrator is based on a possible view of the matter, the court should not interfere. But where on a full reading of the contract, the view of the arbitral tribunal on the terms of a contract is not a possible view, the award would be considered perverse and as such amenable to interference. So, my lord, here if I pause here for a moment, what are they trying to say? They are trying to raise a challenge to the clause itself, enforceability of the clause itself. That the arbitrator has said that it is not permissible in the face of the case which has been made out in this statement of claim. So he has taken note of their submission, oral submission. So here, my lord, I say that the arbitrator has considered 8.3.2.2, made an interpretation of the clause based on the conduct of the parties, including correspondence exchanged, circumstances of the case, and pleadings of the parties. Based on this, he has interpreted it. If not, on the basis of this, he has not accepted their stand that this clause cannot be rendered otiose and declared as void, that cannot be termed as a perversity. He has interpreted the clause based on these circumstances. You have to show interpretation is not possible. This interpretation was not possible. What is your stand? Well, kindly remember, their only stand was this kind of a clause cannot stand legal scrutiny. It is void. This was the stand. That, well, it is, if the arbitrator does not accept your case based on your pleadings, that cannot amount to, my lord, an unreasonable, implausible interpretation. That too, my lord, I will make this argument also, my lord, though may not be necessary. This type of a clause cannot, on the face of it, be said to be non-efficacious. A statutory right which is conferred for benefit of a party can be waived. It is open to the party to choose its right. It is not like an inviolable right. And I need not go because that is not your case in the statement of claim. So, my lord, this is so these are the kindly read, my lord, the next part also, paragraph 85.
Yes.
Ordinarily, the terms of the contract are to be understood in the way the parties wanted and intended them to be. How can the arbitrator on his own say that 8.3 will not be enforced? Where is your stand during the course of execution of the contract that this is a clause which I do not accept, or I am forced to accept this clause? So ordinarily, this clause has to be binding against you. In the agreements of arbitration, so they have not shown anything to your lordship that I have already raised contemporaneously this issue regarding the clause being unworkable or not efficacious. In agreements of arbitration, where party autonomy is the ground norm, how the parties worked out the agreement is one of the indicators to decipher the intention, apart from the plain or grammatical meaning of the expression used. So this is also extremely relevant. How you have worked out the agreement. Now, my lord, kindly come to page 164. Para 164. In these circumstances, though para 16.03D of the award gives the impression that limitation was extended because negotiations were going on in respect of items related to the claim, the limitation was extended by applying the principle of acknowledgement as enshrined in section 18 of the 96(3) Act on the basis of two documents, that is minutes of meeting dated 19th April 2018 and the offer letter dated 26 May 2018. Importantly, principle of extension of limitation by acknowledgement was applied in respect of only those claims regarding which a mention was there in the minutes of the meeting dated 19th April 2018. In respect of claims regarding which there was no recital in the minutes, the tribunal observed that they were not part of the negotiations. Thus, though the term used in para 16.03D of the award is negotiations, the tribunal, by referring to the minutes dated 19th April 2018 and settlement offer dated 26 May 2018, indicated the underlying legal principle rationale behind its conclusion. We therefore conclude that though the reasons recorded in the award at first blush appeared insufficient or a bit confusing, but when those reasons are examined in the context of the documents placed and the arguments advanced, the underlying reasons which form basis of the conclusion are not only intelligible but sound. For the aforesaid reasons, in light of the law exponent para 18, we reject the submission. So this was on the aspect of the reason and the sufficiency of the reason. Hmm.
We want to have challenge during our
Yes, well, let us read this 2007 volume 2 SCC 453. There was a similar clause four five three. Kindly come to paragraph 6, very short, just for the fact. Here also, my lord, the basis of the disputed claim is that execution of work was delayed on account of breaches on the part of the employer, and the employer is liable to compensate the contractor for all losses and extra cost on account of delay and extended execution. Here, my lord, the arbitrator held otherwise, that where kindly see para A, work was delayed due to attributable to the employer, grant of extension of time by the employer does not exonerate employer from liability to pay damages. So award was granted. These awards were affirmed by the single judge. Then the division bench referred to clause 11C of the contract. They held that the awards were in derogation of clause 11C. Now kindly see, my lord, paragraph 9. Your lordship has seen paragraph 9. Division bench of the High Court, after considering the threadbare submission question of law, arrived at the conclusion the arbitrator has exceeded in jurisdiction in making an award towards claim 24 in the hanger contract and award towards road contract. They were made in derogation of clause 11C, which prohibited the contractor from making any claim for compensation or otherwise, howsoever arising as a result of extension of time granted under the contract. So similar clause was involved. If your lordship comes to the next page, para 11, that clause is quoted. In fact, top of the page, your lordship will get the issue whether the arbitrator committed a legal misconduct for not acting in terms of clause 11C of the contract, though pleaded and submitted before him. Kindly turns the next page, just above paragraph 12, that clause is there. C.
No claim.
Yes. No claim in respect of compensation or otherwise, howsoever arising as a result of extensions granted under condition A and B above shall be admitted. Now, para 12 is important. Clause C provides that where extensions have been granted by reason of delays enumerated in Clause A, which were beyond the control of the contractor on account of delays on the part of the employer specified in Clause B, contractor is not entitled to make any claim either for compensation or otherwise arising in whatsoever manner as a result of such extensions. After enumerating certain delays, subclause 7 of Clause A specifically delay on account of any other cause beyond the control of the contractor. The causes for delay specified in Clause A thus encompass all delays over which contractor has no control. This will necessarily include any delay attributable to the employer or any delay for which both employer and the contractor are responsible. The contract thus provides that if there is any delay attributable either to contractor or to employer or to both, the contractor seeks and obtain extension of time for execution on that account, he will not be entitled to claim a compensation of any nature on the ground of such delay in addition to the extension of time obtained by him. Therefore, the claims for compensation as a consequence of delays, that is claim 24 of the hanger road, are barred by clause 11C. So we have a similar clause here. The arbitrator has gone by the reading of that clause. He has interpreted the clause. So, and your lordship will find in para 16 that this question is answered in the affirmative. Now, kindly come to paragraph 18 also. In spite of having held that both were responsible for the delay and having noticed the argument based on clause 11C of the general conditions of contract, the arbitrator proceeded to award damages on the ground of delay on the reasoning that the contractor is entitled to compensation unless the employer establishes that the contractor has consented to accept extension of time alone in satisfaction of his claim for delay. As rightly held by the High Court, which decision we have affirmed while considering question 1, clause 11C of the general conditions of contract is a clear bar to any claim for compensation for delays in respect of which extensions have been sought and obtained. Clause 11C amounts to a specific consent by the contractor to accept extension of time alone in satisfaction of his claims for delay and not claim any compensation. In view of the bar against award of damages on account of delay, the arbitrator clearly exceeded his jurisdiction in awarding damages, ignoring clause 11C. I'll just show clause 8.3 once how well we are placed insofar as 8.3 is concerned. Yes. See that volume 1 itself, page 128. Not she has got 8.3. In case of delay on the part of the contractor shall be liable to pay liquidated damages, any other compensation for damages suffered by the employer. Next paragraph. Failure or delay by the employer or the engineer to hand over to the contractor the site necessary for execution of the works or any part of the works, ought to give reasonable necessary notice to commence the works, or to provide necessary drawings or instructions or clarifications, or to supply any material, plant or machinery which under the contract is the responsibility of the employer, shall in no way affect or vitiate the contract or alter the character thereof, or entitle the contractor to damages or compensation thereof. But in any such case, the engineer shall extend the time period for completion of the contract as in his opinion is or are reasonable. And clause 2.2 also at page 98. Kindly see 2.2. Yes. The employer shall grant the contractor, Lordship has got
Yes, yes. The
the
employer shall grant the contractor
right of access to possession of the site progressively for completion of the works. Such right and possession may not be exclusive to the contractor. Contractor will modify the schedule for completion of works according to progressively possession right of such. If the contractor suffers delay from failure on the part of the employer to grant right of access to or possession of the site, contractor shall give notice to the engineer in a period of 20 days. After receipt of such notice, the engineer shall proceed to determine any extension of time which the contractor is entitled and shall notify the contractor. For such delay in handing over of site, contractor will be entitled only to reasonable extension and no monetary claims whatsoever shall be paid or entertained. Now, if the conduct of the parties is to be seen, well, there is unconditional acceptance of this. There is no reservation of right with regard to this clause. So how could the arbitrator have entertained the submission for not giving effect to this clause and deciding the claims dehodes this clause? That would amount to a patent illegality. You are going beyond the contract. Yes, just on this point, I'll just refer to a copy. This is also, my lord, on the point, my lord, if the point has not been raised before the arbitrator, my lord, it cannot be raised in a 34 for the first time. This is large. Paragraph 15. The sole issue which arises for consideration in the present petition is whether the 15, sorry. And your lordship will find that this is the same clause which is involved here, 2.2 and 8.3. The issue which arises for consideration in the present petition is whether the decision of the arbitral tribunal in disallowing the claim for idling of main machinery and resources suffers from any of the shortcomings elucidated in section 34 of the Act. The AT, while disallowing the claim, has rightly held that the adjudication of the claims has to be done within the framework of the contract between the parties. This is the leitmotif of judicial pronouncements on the subject. The AT interpreted clause 2.2 and 8.3 to reject the petitioner's contention. A brief analysis of these clauses is necessary to trace the AT's reasoning. Then 17 and 18, my lord, deals with 8.3. I am not troubling your lordship. Kindly come to 19. However, this clause 8.3, insofar as delay attributable to the contractor is concerned, lays down strikingly different consequences, makes the contractor liable to pay liquidated damages and any other compensation suffered by the employer due to delay. Evidently, parties have consciously, willingly, in the absence of any challenge to the disparity in the said clauses of the consequences for the parties due to the delay, agreed to such contractual arrangement. Parties chose to restrict the provision of LD to delays on behalf of contractor, did not extend the same to delay on the part of the employer. As stated above, there was no challenge to the said clause before the tribunal or any time earlier, at the time of signing of the contract, during its execution, or thereafter. It is not open to the petitioner to fault the award under 34 by way of oblique references to the legality of 8.3. In fact, the conduct of the petitioner would show that it was conscious of the absence of a right to claim compensation, as is evident from the letter dated such and such, where the petitioner, while seeking extension of time, though attributing delay due to lack of requisite approvals and site availability, never sought any compensation for such delay. In my case, it is also same. They have only sought for extension of time given the hindrances. The extension of time was granted by respondent by letter dated such and such. It was specified that extension was without any penalty. Petitioner sought compensation for delay at a later point in time by later dated such and such. Same was denied by the respondent on time citing clause 2.2. There is no ambiguity in law with respect to the AT being the best judge of the facts, and the parties cannot ask the court to reappreciate evidence on a 34 petition. AT has power to interpret the provisions, accordingly give a decision in the prevalent factual matrix. According to this court, it will be legally impermissible for it to interfere with the award on the interpretative differences of the contract clauses. The Supreme Court in such and such, also if a plea was not raised before the AT, the same amounts to clear case of waiver or abandonment of plea at the initial stage. Then para 23, since the AT was never seized of any challenge to 2.2 and 8.3, it never had the opportunity to give any finding in respect of their validity. In such a scenario, this court would refrain from entering into a detailed exercise the validity of these clauses. The only paragraph which is there in the statement of claim, I'll show your lordship, paragraph 21, page 235. That is volume 2. ওরা কোনটা দেখিয়েছিল? সত্যপালন দেখিয়েছিল না? ওরা সত্যপালন দেখিয়েছিল। Page 235.
21.
Yes. After referring to the letters, they say, in this regard, it is respectfully submitted that when a breach is committed by one of the contracting party, other party is entitled to suitable conditions. This is the settled law. Contention of GC that such claim is impermissible under the terms of contract is thus totally not sustainable. The terms of the contract lost its relevance when the nature of breach exceeds the reasonable anticipation of the parties at the time of conclusion of the contract. So they are accepting 8.3. They want 8.3 to be interpreted in a certain manner, nothing else. But kindly, your lordship has noted what their submission was before the arbitrator. They are trying to say, declare it as void and pass an award of my claim irrespective of 8.3. Yes, but they had cited a judgment which is 2007, 13 SCC, page 43. This is the judgment, my lord, the contractor, my lord, whenever I am also there on the side of the contractor, this is, my lord, a Bible to come out of this type of a clause. But unfortunately, my lord, the facts are very clearly distinguishable. There is a difficulty, but one or two lines in a judgment, they tend to lead to some amount of confusion. Kindly come to, my lord, here, paragraph 9 of the judgment. The agreement relating to handing over, lordship has got it. The agreement relating to the handing over of the site to the claimant was executed on 10th October and 25th of the respondents instructed the claimant to start the work and complete the same within the agreement period of 11 months. However, while the period of completion of 11 months for the whole work was to expire on 24th September 86, same could not be completed on the scheduled date, and under clause 50, extension of time was sought by the appellant for completing the work. Clause 50 of the general conditions of contract provides, kindly note this, if failure to comply was the result of delays on the part of the government in supplying materials or equipment it had undertaken to supply, or from delays in handing over sites, or from increase in quantity of the work to be done on the contract or force majeure, an appropriate extension of time would be given. So this was the clause. Finding that the said clause was operative, respondent extended the time of completion, but while doing so made it conditional that such extension of time would be subject to execution of supplemental agreement to the effect that the contractor would not be eligible for any enhanced rate for the work during the extended period. According to the appellant, he had no option but to sign the agreement, though under protest, since he had undertaken to complete the work. So 2 points of difference. Original contractual clause did not bar damages, unlike my clause. Second point of difference, when the employer granted extension, they incorporated that clause by way of a supplemental agreement that I am granting you extension, but you cannot claim damages. And this was not unconditionally accepted by the contractor. He had signed that supplemental agreement under protest. So now your lordship will read the paragraph which my learned friend has placed. Paragraph 18. Admittedly, original agreement did not contain a clause for escalation of rates. On the other hand, supplemental agreement contained a specific provision that contractor would carry out all further works within the extended period at the rates and in a manner agreed to in the agreement, and would not claim any enhanced rate for such item of work on account of extension of time, either due to increase in rate of labor or materials or any ground. High Court took the view that although arbitrator had come to a finding that the appellant had to execute the supplemental agreement under force of circumstances, there was no material before the arbitrator in support of such contention. On such finding also, High Court held that the arbitrator had acted beyond his jurisdiction in allowing claim G. Now kindly come to, my lord, these paragraph which my learned friend had placed. Paragraph 31. So this was the circumstance. The 31 first. Page 51.
Yes.
The question which we are called upon to answer in the instant appeal is whether, in absence of a price escalation clause in the original agreement and a specific prohibition to the contrary in the supplemental agreement, the appellant could have made any claim on account of escalation of costs, and whether the arbitrator exceeded his jurisdiction in allowing claims has been found by the High Court. But before going to 32, your lordship will remember, therefore, that the supplemental agreement was under protest. That is the more important fact. Para 32. Ordinarily, the parties would be bound by the terms agreed upon in the contract. But in the event one of the parties to the contract is unable to fulfill its obligation under the contract, which has a direct bearing on the work to be executed by the other party, the arbitrator is vested with authority to compensate the second party for the extra cost incurred by him as a result of the failure of the first party to live up to its obligation. That is the distinguishing feature of the case of this nature, and Alopi Prasad and also Patel Engineer, as pointed out by Mr. Dave. Said principle was recognized by the court in PM Paul, where a reference was made to retired to fix responsible for delay in construction of building. Based on the findings of this court, gave its approval to the excess amount awarded by the arbitrator on account of increase in price of materials during the extended period of the contract, even in the absence of any escalation clause. Absence and there being a bar is different. Contract is silent. It is well within the scope of the arbitrator to import Section 73 of the Contract Act. But there is a specific bar. Next, para 33. We have intentionally set out the background in which arbitrator made his award in order to examine the genuineness and validity of the. It is quite apparent that appellant was prevented by unforeseen circumstances from completing the work within the stipulated period. Delay could have been prevented had the state government stepped in to maintain the law and order problem which has been created. Rubble and metal. Even in the aforesaid circumstances, arbitrators have to appear to have acted within his jurisdiction, allowing some of the claim on account of escalation of costs which are referable to execution of the work during the extended period. These are the two distinct. Original contract did not bar damages. Silent. You have caused me to enter into a contract where you are using your bargaining power at the middle of the contract to impose a condition for barring damages. I have executed that under protest. So on these two facts, the court says that the arbitrator is well within his rights to give damages. This is completely distinguishable, my lord, from our case, my lord. So, my lord, this is insofar as my claim number 1 is concerned. My lord,
how many more claims?
Half an hour for the claim number 3. I'll finish, my lord, the next day itself, my lord.
When do you want?
And I don't think claim. I come back on Monday, my lord. I have to get ready also, my lord. I think a half an hour should suffice. Because that I don't think that claim is
Not tomorrow. Not tomorrow.
I need to.
And how much time will you take?
I have to speak to Mr. Jishnu Shah, who is leading it. But there are few points which definitely has to be addressed before Lordship. It will take at least half an hour, in my anticipation.
Heard. Heard, Learned Senior Counsel. Hussain.
9,
List
10,
for
9,
further hearing on.
9, 10, 10th.
No, no, can't be done. Can't be done. On 25th February.
Kota? Which date?
Lordship is circuit.
Okay.
24th February.
24th.
Oblige.
Good Indian.
25th, can it be done instead of 24th?
25th, I have kept a matter. Note that.
Or 23rd?
23rd is a Monday. I can. 23rd you want?
23rd?
23rd I can.
Good. Very well, your lordship will keep it. 23rd.
23rd? 23rd.
Non-commercial matter. Number 1.
At number 1, my lord, I am for the petition, my lord. I am paying for not today, my lord. I am being led by London Senior Counsel DN Soma, my lord, who has not come to court due to some personal reasons. Now, kindly make it not today only.
Not today.
Deeply obliged, my lord. Deeply obliged.
My lord, I have to call petition. 5 analogous matter are, my lord.
Yes.
Application under section.
And my senior is in another court.
Huh? Call him, call him. Yes.
Learned arbitrator, my lord, after also hearing also, my lord, he left the office. And for the reason, my lord, I filed this application for terminate his appointment and to appoint a new arbitrator, my lord. This is the application, my lord, in short.
Yes. Yes. You're seeking substitution of the arbitrator.
Yes, my lord.
Yes. What are the grounds, sir?
Ground, sir, my lord, ground is the arbitration proceeding was started, my lord, long back, my lord. Then both the party appear and the arbitration proceeding was concluded by the learned arbitrator. Thereafter, my lord, without giving any notice or any other taking any step, the learned arbitrator left the office. And this
application is pending for a long time, my lord. This.
The only ground which I can see from the petition is that he had not passed the award because the payment was not made to him.
No, 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 my lord. Payment already made, my lord. It my application last.
It is only for publication of the award now.
Yes, my lord.
So at this stage, why should we change the arbitrator?
My lord, then the learned arbitrator is not taking any step for a long time, my lord. And
Get the mandate of the arbitrator extended. You are also not filing any application.
well,
Mandate has expired.
we have hearing was concluded, my lord. Only it was fixed for
That's what I'm saying, sir. Move an application for extension of the mandate of the arbitral tribunal. He will publish the award. This can't be a ground to change the arbitrator.
my lord. He left the office, my lord. Then how we shall move this application?
What he left the office? What do you mean by he left the office?
My lord, he's after hearing he is not taking this matter, my lord. No notice, nothing is. We have requested on several occasions, my lord.
Sir, you show me the law that you can change it like this. Where is the law? Can't just file applications without any head and tail. Show me the law. How does it become de jure or de facto?
Lordship, kindly, the matter was last annexure, your Lordship, kindly look. Last annexure.
My lord, I am opposing this application.
I'm seeing that although the award are ready to be pronounced or delivered to the respective parties in respect of the caption 5 arbitration in view of the fact that the parties have not paid the fees.
No.
So I'm unable to pronounce or deliver the said award
Lordship,
to the
kindly,
respective. How has he left the office?
my lord, without anything, my lord, the matter is pending since long, my lord.
All right.
Your Lordship, kindly look into the last annexure, my lord. As per the
Sir, that is what I'm looking at. That is what I'm reading.
Fourth, according to fourth schedule, we have paid all the amounts. Both the party.
Move an application under 29A for extension of the mandate of the arbitral tribunal so that he can pronounce the award.
May I submit, my lord? This application is fractious, my lord. Because, my lord, the time was expired. The last order was given on 21st, on 3rd of September 2024, my lord. It was extended for 2 months. That expires on 3rd November 2024, my lord. So the mandate of the arbitrator already terminated after that.
It
So
doesn't
the
get
arbitration
terminated. Who says it gets terminated, sir?
My lord, after 1 year, my lord, from the pleadings.
Yes.
So pleading is
You can get an extension under 29A.
Yes, my lord, extension was
File an application for extension.
We have earlier, my lord, I have taken an
Take
extension.
one more so that he can publish the award, sir. This can't be a ground for termination.
My lord, may I submit, my lord, but today there is no arbitration proceeding pending, my lord, because the termination was because it was not extended after November 2024. It has already expired, my lord. So today the proceeding is dead, my lord. There is no proceeding pending before the arbitrator. We have to file a fresh proceeding after issuing section 21 notice, my lord, because it is the second round of arbitration, my lord. This arbitration goes, my lord. According to my submission, my lord.
Show me the law that it goes.
My lord,
They
because,
can still move an application
first,
under
my lord,
29A.
on the fact, my lord,
Yes.
had it been in the extended period, my lord, they come, that the arbitrator is not proceeding well, or arbitrator, I have to remove the arbitrator, I have to appoint new arbitrator. It is well defined, my lord. If they are coming in within the arbitration proceeding is alive. Today, the arbitration proceeding is not alive. After November 2024, they are coming on 10th of July. They have filed this application, my lord. They could file application under 29A, my lord, in the month of December, as soon as the extension is expired. They have not come, my lord. They have chosen not to come before the court. And in July 2025, they have come with application for removal of the arbitrator, where there is no arbitration proceeding is pending. So arbitration proceeding is not alive now. Already it is mandate is already terminated, my lord.
Mandate.
Yes.
Mandate is terminated. We have, before termination of the mandate, my lord, we have paid his fees also, my lord. Full
He is
fees,
the arbitrator, sir.
my lord.
He is not the arbitrator.
No, my lord, he is the opposite party, I know. But against him, the arbitration proceeding is taken, my lord.
You should have filed an application under 29A to get the mandate extended for publication of the award. Everything has been done.
Everything has been done. It is right, my lord.
Move an application, sir, under 29A for publication of the award. And there he will raise his contention that it is delayed and blah, 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 whatever it is. This is not maintainable. Take down. The petitioner has filed the present application under section 14 and 15 of the Arbitration and Conciliation Act, whereby seeking termination of the mandate of the learned sole arbitrator on the ground of alleged delay in conducting the arbitral proceedings. Full stop. It is the contention of the learned counsel for the petitioner that this court, by order dated 13/4/2022, appointed the learned sole arbitrator to adjudicate the dispute between the parties. Full stop. The pleadings were completed on 21/12/2022. Full stop. With the consent of the parties, the mandate of the arbitral tribunal was extended up to 36/2024. Full stop. Thereafter, by an order dated 3/9/2024, this court further extended the mandate for a period of 2 months. Full stop. It is further submitted by the learned counsel for the petitioner that the proceedings stood concluded, and only pronouncement of the arbitral award remained. Full stop. It is further submitted that the learned sole arbitrator, by email dated 11th of June 2024, informed both the parties that the arbitral award was ready to be published. Full stop. However, the learned arbitrator recorded that both the parties had failed to make the payment towards the arbitral fees, and accordingly called upon the parties to deposit the fees. Full stop. The grievance of the petitioner is that despite lapse of considerable time thereafter, the learned sole arbitrator has not pronounced the arbitral award. And on this basis, the petitioner seeks termination of the mandate and substitution of the arbitrator. Learned counsel for this is the ground, sir. Anything else?
That is the ground.
Okay. Learned counsel for the respondent submits that the arbitral tribunal the mandate of the arbitral tribunal stood terminated since the last proceedings were held on
my lord.
Since the mandate was extended only till
Till it was for 2 months from 3rd September
till
to 3rd
3/11
November. 3rd November.
3/11/2024. I think the learned counsel for the respondent states that this court, while ordered it so and so, had extended the mandate of the arbitral tribunal only for 2 months, which came to an end on 3/11/2024. Thus, his contention is that since the petitioner had not filed any application under Section 29A of the Arbitration and Conciliation Act for extension of the mandate of the arbitral tribunal, the mandate automatically stood terminated, and that the present application, which has been filed on 10/7/2024,
25, 10th July 2025
itself is infructuous and not maintainable. Full stop. It is further submitted that the aforesaid grounds do not attract the provision of Section 14 of the Act. Full stop. Near non-payment or delayed payment of arbitral fees by the parties.
Payment was made in time.
I'm just recording submission of the fees or the consequential non-pronouncement of the award does not render the learned arbitrator either de jure or de facto incapable of performing his functions. Full stop. There is no statutory disqualification, legitimate impediment or inability attributable to the learned sole arbitrator which justify termination of the mandate. Full stop. It is further submitted that delay in pronouncement of the award, particularly when attributable to non-compliance by the parties in depositing the arbitral fees, cannot be constituted as a legal incapacity.
Arbitration fees already paid.
Wait, sir.
Yes, my lord.
Can you wait? And please do not interfere when the court is dictating the order. You say it afterwards. Non-deposit of the arbitral fees cannot be constituted as a legal incapacity of the arbitrator. Full stop. At best, such circumstances may warrant appropriate direction for expeditious pronouncement of the award or extension of time, but cannot form the basis of termination of the mandate under Section 14 and 15 of the Arbitration and Conciliation Act. Full stop. Learned counsel for the petitioner states that the arbitral fees had been paid to the arbitrator, though the arbitrator did not render the award. Full stop. In the absence of de jure or de facto, in the absence of de jure, incapacity, ineligibility, bias, or failure on the part of the learned arbitrator to act independently or impartiality, the prayer for termination of the mandate and the substitution of the arbitrator is misconceived and untenable in law. Full stop. In view of the above, the present application is dismissed. Full stop. The petitioner is, however, is dismissed. With the above aforesaid direction, the present petition stands dismissed. The dates of all the orders are the same. The dates are the same in all the 5.
All the 5. Yes.
My lord has dismissed the application, my lord. My lord.
Yes.
My lord. Great.
I have dismissed the application.
With liberty to
With liberty to what?
with liberty to extension of the
With liberty to?
mandate of the arbitrator.
You can do whatever with liberty to file appropriate application in accordance with law. Whatever the liberty is, you avail it. 226, right?
226. My lord,
Are the dates same?
Same.
Yes, same. That's
Same
analogous
arbitrator.
matter.
Analogous matter.
All different. All different.
My lord, may I trouble your lordship for the section for a once, my lord?
Section?
29A, subsection 4, my lord. Subsection 4, proviso, my lord. Second proviso, my lord. Second proviso, provided further that where an application under subsection 5 is pending, the mandate of the arbitrator shall continue till the disposal of the application. Here, Mala, in this case, there is no such application is pending before your lordship.
You argue this at the time of your 29A application.
My lord, grateful.
Next.
I appear for the petition. I'm being led by Mr. Ray.
Yes.
My lord, here one humble prayer. My lord, our advocate on record, my lord, he has been, my lord, he's not been able to come to court. My lord, he's actually been blessed with child, therefore he's not coming to court for the last 2 days. This is my instruction, my lord. So there was a direction upon, my lord, for us to
Child care leave.
But that's why I told him, please. I'm sorry.
Finding it a bit. Mr. Ray, child care leave.
My lord,
This is my lord, this is instruction.
Bit flabbergasted.
a lot of things come up in court, including this one.
This is my
We were all geared to ask for the convenience compilation, which has not been
There was a
given.
with my
Yes,
learned.
where?
There was a direction, my lord, both the parties were supposed to make it.
Yes.
For some reason, it has not been made. But before that, my lord, I find that this should appear, I'm subject to what Mr. Banerjee feels, it should appear in the commercial side, my lord, because this appears to be a commercial dispute. So if that could, your lordship can extend the time for a few weeks, my lord, and it could appear on the commercial side with the compilation, my lord.
But has it been filed in the commercial side, Mr. Ray?
The affirmation is just before the notification, my lord.
No, but it has to be filed before the commercial side, I thought.
It can be
It can be
renumbered.
renumbered, but on section 15, it can be, my lord.
It can be renumbered. Is it a commercial dispute, Mr. Banerjee?
And out of transactions of
1C what?
my lord, one
21C1.
sale of coke, my lord, coal, my lord, and payment due and payable under that.
Learned counsel, parties submit that the present dispute pertains to commercial dispute under section 21C1 of the Commercial Disputes Act. Commercial. Full stop. Yes, Mr. Banerjee was saying something.
No, I'm sorry, my lord. I have not checked myself. If yes, it is mercantile. If Mr. Ray has checked, I hope that's. I mean, it's his application, so I'm more concerned about.
Well, at price of goods sold and delivered, and my lord, there's a scope of damages which we had claimed under the same, the some of the invoices, my lord. So repeated contracts, my lord. So
Let the registry renumber the petition on the commercial side. The same shall be done within 2 weeks. List after 2 weeks.
Grateful.
Please, in the commercial division.
well, this to appear in the monthly, your lordship has passed,
Let it appear in the monthly list of March.
and we'll get the compilation.
Grateful.
Very grateful.
Grateful.
So I'll record that. In the meantime, the parties seek further time to file their joint
Compilation.
convenience compilation set.
Yeah.
Seeks an
Grateful.
time of 2 weeks. 2 weeks, 3 weeks.
But by the monthly, by the return
The time of 3 weeks.
Very grateful.
Great. Grateful.
I'm opposing one of the 34. Last time also, no one appeared.
Order record
Lordship has recorded an order last time also.
Just give it to dismiss and default.
Yes, my lord.
None appears for the petitioner. Even on the earlier occasion, i.e. 28 January 2026, there was no appearance on behalf of the petitioner. Let this matter be dismissed for default. Let him file an application.
Yes, let him file an application. Respondent has appeared, that your lordship. Yes.
Respondents.
Oblate.
My lord, I am appearing for the petitioner, my lord. In this matter, your lordship may kindly recall that on last occasion, your lordship, my learned friend took some objection regarding the territorial jurisdiction, my lord.
Yes.
According to my learned friend, that since there is a general clause in which my client has signed that the territorial jurisdiction should be Mumbai.
Yes.
To that, my reply is that even though I have signed the agreement, but my right to file this application in Calcutta still subsists, since the cause of action has arisen in Calcutta, my lord.
Sir, we
My
go
lord,
by the agreement.
my lord, I have come today. I have come prepared with some judgments, my lord. Wherein
The other side.
Huh?
Where's the other side?
Other side is not present, my lord. Is today.
Not today.
Not today. Other side.
Not today.
Not today. Wait for